active since 17/10/2025. He has further submitted that the bail application of the petitioner was rejected earlier on 10/3/2026 in the A number 1299 of 2026 by this court. And at that point of time, the seizure witnesses were not examined. The allegation against the petitioner is that the petitioner was the driver of the motorcycle and 5 kg of ganja was recovered from the possession of the person who was riding the motorcycle with him in a bag.
From the person who was behind.
That's it. That's it. Who is the co-accused in this case? The learned counsel submits that the co-accused has been enlarged on bail by a coordinate bench in DA number 1181 of 2026 by order dated 15/4/2026. He has further submitted that after the order of rejection, 2 prosecution witnesses who were the seizure witnesses have been examined before the learned court, and the cross-examination reveals that they have not fully supported the case of the prosecution. Rather, one of the witnesses has said that he was around 20 to 25 meters away and he could not say as to what all were recovered. The learned counsel for the state has opposed the prayer for bail and has submitted that even if it is intermediary quantity, yes, but there is presumption of guilt.
Yes, under section 45 of NDPS.
There is presumption of guilt under section 45 of NDPS
35.
Act. Sorry, 45. 35 of NDPS Act. And since the substance was recovered from the joint possession of the petitioner and the co-accused, the petitioner may not be enlarged on bail. However, during the course of arguments, it is not any dispute that the petitioner does not have any criminal antecedent. Nahi hai na? Also, it appears that the seizure witnesses have not fully supported the prosecution case. And the petitioner does not have any criminal antecedent. The petitioner is elected to be enlarged on bail. However, the learned court shall, before releasing the petitioner on bail, shall call for a report from the police with regard to the criminal antecedent of the petitioner. If any antecedent is found, the petitioner shall not be released on bail.
Item 7 DT.06.07.2026.
Case of the petitioner under section 80, 351 to 35 of the BNS Act. The very outset was I requested for the case there in view of the para 11 of my bail application. It is required to receive. Para 11 of my bail application.
Yes.
Case there is required in that.
You just tell me what is it?
Yes, ma'am.
No, but that is not sufficient. There is direct allegation against it. There is direct allegation against it.
But the witnesses are not
Not
supported.
required.
Not the demand of dowry is at least required to be stated by the witnesses. That has not been stated by any of the witnesses.
Informant ने किया है demand of dowry का.
Only informant have stated,
That is
and but
enough.
none of the other witnesses have
That is
stated.
enough.
Lords, may kindly
I am not
consider.
inclined. Mr. Modi, I am not inclined. I am telling you.
Lords, in other cases, Lordships have called cases there in such cases where the witnesses are not supported. Therefore, I am saying only to
That's
call for the case diary.
You did the FIR.
Yes. Lordships have called in other
You
cases.
read the FIR.
Yes, Lords. I am reading it, but
अब एक केस में दो co-accused का तो parity चलता है. एक केस से दूसरा केस से parity चलता है.
similar cases where
I just don't understand. What do you mean similar cases?
Lords, in
Is
the
there,
case
is
of,
there only two similar cases?
Lords, in the case of
You
dowry,
read the
there,
FIR, please.
yes, Lords. In case of dowry,
You read the FIR.
yes, Lords. निवेदन पूर्वक कहना है कि मैं मोहम्मद हुसैन अंसारी सज्जन सच जिला दिल्ली का निवासी हूँ। हम अपनी भगनी मनीषा खातून को बचपन से अपने घर में रखकर भरण पोषण, रहना, खाना पीना एवं सभी जरूरत का सामान देकर रखे थे और करीब 3 माह पूर्व अपनी भगनी का मनीषा खातून सज्जन सच की शादी मुस्लिम रीति रिवाज से आशिक अंसारी पिता सज्जन सच जिला विधि के साथ अपने सामर्थ्य के अनुसार दहेज के रूप में 2 लाख रुपये नगद एवं 1.5 लाख रुपये का सामान देकर दिनांक 1/12/25 को शादी संपन्न हुआ था। उसके बाद मेरी भगनी को 2 सप्ताह तक सही सलामत रखा गया, जिसके बाद मेरी भगनी को ससुराल वाले आशिक अंसारी, ससुर सलीम अंसारी, सास नैसरा खातून, these 2 persons have been granted bail, ननद आशियाना खातून, सभी मिलकर और भी दहेज के रूप में एक अपाचे मोटरसाइकिल जिसका कीमत करीब 1,55,000 रुपए की मांग करने लगा और हमकी कहना कि अगर अपने मामा का घर चलाकर नहीं दो तो तुमको जान से मार कर फेंक देंगे और तरह तरह का यातना प्रताड़ना करना शुरू कर दिया और मेरी भगनी को उसके पति मोबाइल के माध्यम से हमेशा दहेज नहीं देने पर जान से मरवाकर फेंकवा देने का धमकी देता था। परंतु आज दिनांक 29 और 26 को समय करीब 10 बजे मोबाइल के माध्यम से सूचना मिला कि आपकी भगनी जो सिंवरिया में रहती है मनीषा खातून को मर गई है। तब आनंद खान अपनी भगनी का ससुराल से दरबार गया तो देखा कि मेरी भगनी अपने कमरा में दुपट्टा से गला में लगा हुआ कंधा के साथ लटका हुआ था, जिससे मुझे पूर्ण विश्वास है कि उपरोक्त लोगों के द्वारा मिलकर मेरी भगनी की हत्या की गई है। Now the cause of death note as per the implement order notes is at page 16 notes, last line. Cause of death is asphyxia due to hanging. No other injury was found on her body. Now, notes para 9, I stated that on the date of occurrence, this petitioner was at Mumbai on his job. The father-in-law and mother-in-law have already been granted bail, that is annexure 2. And in para 11, I have stated that none of the witnesses have supported the case of demand of dowry. It was only because the husband, after few days of marriage, has went to his job and she was not happy that the husband has left her and had gone to his work. She committed suicide. Therefore, I was saying that the diary is required in the case where the support of demand of dowry is not made by any of the witnesses. Almost there are 7 to 8 witnesses have been examined of the locality who have not supported the case so far as demand is concerned.
PA number 6144 of 2026. Heard the learned counsel opinion on behalf of the petitioner.
And my case is better than that.
I heard you.
My parents-in-law. That
I heard you. I will record every submission what you have made. If I miss any one of them, you can tell.
No, at least diary is required to verify the statement at what the witnesses have said, not at least.
That's it. I've heard you, no?
No, see, at least
I
the
heard you
statement may be verified, not in this
Mr.
regard.
Modi, you can go on till 4:30. But I've heard you and let
You
me
know, Sir
pass.
Lordship have called case diary in so
Heard
many
the
cases.
petitioner order is the post for orders tomorrow.
Sir
Then-
Lordship
I've heard it.
Sir Lordship
I've
have
heard
called for case diary in so many cases.
Okay,
You know,
tomorrow.
where the demand of dowry is
I've heard
against
you.
the in-laws.
I've heard you.
So,
I'm posting it for.
I've
I've heard you.
my only submission is
I've
that
heard.
that in similar cases
Mr.
where
Counsel,
the
I'm not inclined to call for the diary.
no, see, in other
Item
cases
eight,
also have called in such cases where the
What do you mean?
26.
Other cases within 15 days of marriage she dies. What do you mean?
Item 8.
What do you want to say? Enough.
in-laws
उनके पति मोबाइल से जो है पैर
कोई बात नहीं छोड़
नहीं
दीजिए ना हम
2 महीने के बाद मरी है 15 डेज में नहीं मरी है
2 ही महीने के
2
बाद
महीने के बाद मरी
काफी
है
है
Lords in other cases Lordship
अरे
have called
you
diary in
have
such
you
cases.
have an appellate remedy. You go and appeal.
Lords, at least diary may be called for it.
Not
Maybe look
required.
at that why the
Calling
what the
for
witnesses
diary
have
is not a
stated.
matter of right. Okay.
Lords, where the witnesses have
Yes,
not
madam,
supported
please
it, what should be done? Lords, in those cases, at least the material collected in investigation should be seen.
We will see. Don't worry about
So, Lords, without diary, how could it be seen, Lords?
it. I will see. I will pass an order, and you will just have a look at the order. Yes, ma'am.
Lords, this is not the some cases Lordship is calling and some cases it is not being called. Lords, this is not fair.
Yes, ma'am.
This is an application for grant of deliberate offence. Initially, the FIR was registered under section 96 of the BNS. Later, cognizance has been taken under section 127, 87, 64, 65, and 6 of the POCSO Act. So, for the allegation is concerned, Lordship, it has been alleged that the broker of the informant left the home without consent on her own. Later suspicion has been
The
raised
learned
that
counsel for the state is directed to serve notice upon the victim. Let the call for the statement of the victim recorded under section 183 BNSS. The learned counsel for the state is directed to file complaint. ठीक है? केस डायरी क्या कब से कस्टडी?
is in custody since 22/1/26. As a matter of fact, Lordship, everywhere they have stated that
Let the case diary call for from the concerned.
Item 9, BS
Just a moment.
615
Counter affidavit will be filed by 28th July 2026.
Item 9, BS 6157 of 2026.
Sorry, why do you want to do? At the request of the counsel for the petitioner postponed.
My lord, I may appear on behalf of the state matter.
The counsel for the state applicant.
Item 10, BS 6158 of 2026.
Cases under section 376, 536 and 6 of the Boston Act. So for the petition.
You read the FIR, madam. Read the- You read the FIR, you never pay for a passport. Read.
So please continue.
Yes.
बजरंगी दास पिता संसद मुजफ्फरपुर इन तीनों ने मेरे आंगन में मुख्य द्वार पर हाथ उठाकर बैठे लोगों ने मेरी री सोनसो एजेड 15 years गांव की उपयोग तीनों ने मिलकर मेरी पुत्री पकड़कर मुंह में कपड़ा दबाकर जबरन उठाकर मेरे घर से
That is absolutely direct allegation, madam.
So the petition is concerned, he is an old man aged about 80 years, my loss. Thereafter, Lordship, there is land dispute between the parties. I have also stated that in my petition, Lordship. And false case was lodged by the informant side, Lordship. Para 9.
Where were you for so many days? What is the date of FIR? What is the date of FIR?
2000. Earlier case was in the year 2020, the complaint case. That was complaint case. And this is the year 2023. 23 to 23.
The earlier case lodged by the informant, Lordship, the petitioner was already acquitted.
You see, in the earlier case, the victim was not examined.
उसमें
Just
March
see,
140
the victim was not examined. Acquittal. You just have a look at it. Victim was never examined, I think. Yes, Mr. Kachek, Mr. Victim was examined.
Already so far, this,
And we are not concerned with the earlier case. Why should we? But in the earlier case, you see, it was an allegation.
Why not the fact has been mentioned? Because not the same not the informant has lodged not the case against it. And not that not the came into acquittal. Because Vijay Barosi did not appear, Marot, because she was knowing that not the same file is false case. Marot, in this case, Marot find that not the present petitioner is aged not 82 years. I am not, he is not the grandfather, not the relation. I have filed not the geological table also to show that not there was land dispute between the parties, not the father of the informant has lost the case, is having the greedy eye over not the ancestral property, and he wanted to Lord pressurize them to Lord the leave their share. Lord, that is not the otherwise Lord this old man aged 82 years will commit Lord this offense along with Lord his nephew and Lord the grandson.
Sir,
Marot, this is a case Marot can see.
you just see there is so much of bleeding, injury, so many things are mentioned in the FIR.
But the allegation in the FIR Lord is because it is therefore Lord the I have Lord the placed Lord the earlier case also. they are in habit of filing these cases, so that because of the land issue. Otherwise, there is no reason. My lord, I have stated this fact in my application, that is apparent from paragraph 11, 12, 11 that so in 3 in the geological table.
82, 83 we act against them.
They will regularly.
हो गया था ना 82,
हाँ,
83.
what I will have surrendered.
That's
Madam, they
sir, I am not inclined.
Madam,
Number
the
six one
Kejari,
five.
at least not the Kejari will record.
Not,
Madam, this old
not
man,
required. कहाँ लिखा है कि old man cannot commit such an offence?
I am not saying so.
Nor
But
it is,
not the-
nor it is biologically proven that old man cannot commit such an offence.
No, I am not saying so. My lord, this not the seeing
Sir,
the
I am not
conduct of the
implying
informant
that's-
also.
Be in
That earlier also, this she had not the case. Other, if not the case would have been true, this person would not have been acquitted. Why she has not appeared because to give the statement question before the trial court? That therefore would have taken
No,
this.
sir, this case earlier, you were an accused in this case.
Yes, Lord,
Show me that you were the accused in this case earlier.
In the complaint,
No, in this
Yes.
annexure 2 is what?
yes,
Annexure 2 is what?
and it's a 7, serial number 7.
Serial number?
7. Guljan Das, umr 80 वर्ष, para page 18.
And she was not examined.
Lord, it
She was never examined. You just see who all have been examined. She was never examined. I do not know under what circumstances she would come to the court and be declared hostile. I can understand that. But victim का examination के बिना कैसे होता है?
Madam, this did not the reply has to
I
be
don't want
there.
to comment because there is
Madam, this
already an
reply
order
should
of
have given
acquittal. I don't
by
want to
the
see.
direct document. This is a prosecution.
That's right.
Prosecution will not be responsible. Lord, this person, but he was facing the trial. There is nothing about that. Lord, he had objected them.
You see, ना तो इंजुरी का ना ही इंजुरी रिपोर्ट मतलब डॉक्टर एग्जामिन नहीं हुआ, कोई नहीं
Injury
एग्जामिन।
हुआ ही नहीं था उसको।
अरे
ये तो
भाई
केस था।
जख्मी की गवाही
90
कराई गई, ना ही जब्ती सूची, ना ही अन्य दस्तावेज साक्ष्य कुछ भी नहीं कराया।
ये गलती अगर ये
हम
है
मान रहे हैं। I'm not commenting on that, but I'm saying that in a case I just do not know how does the prosecution even disclose in this manner, in this state.
This case was lodged under section 147, 323, 149, 504, 149, 506, 149. That is not this charge was framed. So there was no not the injury and not the she has not the alleged that she was not the
Sir, I have heard
obtaining the arrest,
this.
but not that has not been proved
That's
in this case.
Bill number 6158 of 2026, for the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the case was lodged on 20/2/2023 against the petitioner, and earlier also the victim had lost the case in Karra PS case number 60 of 2019 against the petitioner and other accused persons for alleged offence under section 147, 323, 149, 504/149, 506/149 IPC, and the petitioner and others were acquitted, and the victim was never examined before the court. The order of acquittal is dated 13/5/2026. Now, by the fresh, after the lodging of the earlier case, the fresh case was lodged in the year 2020. The learned counsel submits that there is land dispute between the parties, and the petitioner is 82 years of age. the learned counsel for the state has opposed the claim for bail and has submitted that the instant case was lodged during the pendency of the earlier case. Inasmuch as the earlier case was decided on 13/5/2026 and the present case was lodged on 28/2/2023. She has also submitted that process under section 82 and 83 were issued against the petitioner. And there is direct and specific allegation against the petitioner in the FIR itself. After hearing the learned counsel for the parties and considering the specific and direct allegation made against the petitioner in the FIR which was lodged way back in 2023 during the pendency of the earlier case, and the petitioner has been avoiding arrest, and the process under section 82 and 83 were also issued against the petitioner. This court is not inclined to enlarge the petitioner on this instrument.
Item 11, BS 6166 of 2026.
Offences of cyber commenced on the first appeal. Petitioner is in custody since 15/5/2026. No criminal accusation. 2 mobile and 1 civil accusation possession.
Filing counter.
Item 20 is intact.
This is item number
11
11
and 20.
Item number 11 and 20. These two cases arise out of the same FIR. The learned counsel for the state is directed to file counter affidavit along with the criminal antecedent report of the state. Charge sheet has been submitted. What is the date? तो आपका तो इन्वेस्टिगेशन ही नहीं कंप्लीट होगा, हम तो बेल नहीं
उससे पहले कर देंगे।
उससे पहले
चार्जशीट सबमिट
आप ही बताइए कब रखें। The learned counsel has at this along with the criminal antecedent of the petitioner. At this, the learned counsel for the petitioner has submitted that the petitioners are in custody since 15/5/2026. Charge sheet has not yet been submitted. कब रख दें बताइए? गलत है ना, 2 महीना हम यहाँ पे बेल पेंडिंग रख दें कि इन्वेस्टिगेशन कंप्लीट होते रहे. This is not done. I just don't like it. This is not the way. I will keep the matter pending and for the first time examine the materials collected during investigation. Yes. केस फाइल होने के 2 दिन बाद बेल फाइल कर देते हैं, उसके बाद हाईकोर्ट चले आते हैं, हाईकोर्ट में 3 महीना का चलेंगे. नहीं, ऐसा नहीं होगा. देखिए तो दोनों केस में आप ही हैं पिटिशनर और the learned counsel appealing on behalf of the parties. The counsel for the petitioner submit that the petitioner is in custody since 15/5/2026. Yes, 15/5/2026. The FIR of the case reveals that the petitioners were caught red-handed along with mobile and SIM standing in the name of other persons. Admittedly, investigation is still going on. Accordingly, the state is not inclined to enlarge the petition on bail at this stage. आप लोग को भाई इतना तुरंत आ जाते हैं, फिर यहाँ पे 2 महीना हम एडजर्न करते हैं. सुप्रीम कोर्ट बोल रहे हैं कि जल्दी से बेल डिस्पोजल करिए. Why should I adjourn it? You should know when to file a case. How you are apprehended red-handed with mobile and SIM standing in others' name? Why should I grant you bail at the stage of investigation? Okay, next.
Item 12, BS 6178 of 2026. Appearance is
At this stage करेंगे, हम नहीं करेंगे. आप
तो विड्रॉ कर लेते हैं दिस स्टेज में, फिर चार्जशीट के बाद आएंगे, यही लिखा दिया था बिकॉज़
नहीं, हम ऑर्डर करते हैं. At this stage किया, at the stage of investigation करते हैं. It makes no difference. I have already passed over. Yes, petitioner, who is there? In this case, 6178.
Yes.
Yes.
In case of a grant, they will be. Yes, section 80 of BNS Act. Sir, marriage was solemnized, your lordship, in the year 2023, after 3 years back, and there was no demand of dowry. And death was, my submission is death was natural, your lordship. No external injury, no internal injury.
Natural means, what is natural death?
नेचुरल मतलब बीमार पड़ गया उसका death.
कहाँ से बीमारी का कुछ इलाज हुआ होगा ना?
हुआ तो your lordship, only doctor has it is a suspected case of, he has not stated that it is a suspected case of poisoning. Only he has stated that Visra has been
You read the FIR, please.
Yes, sir.
There is no allegation of demand of dowry, right?
Case 30.
हाँ पढ़िए.
सविनय निवेदन यह है कि मैं संति देवी रोड 50वां पति प्रकाश राय ग्राम गणपति थाना रहता जिला गवा जिला गिरिडीह की निवासी हो. मेरी पुत्री सरिता देवी उम्र 20 वर्ष की शादी हिंदू रीति रिवाज के अनुसार वर्ष 2023 में हुई थी. समय के अनुसार 20,000 दान दहेज दिया गया था. इसके बावजूद उसके ससुराल वाले दहेज के लिए मांग किया करते थे. साथ ही फोन पर दहेज को लेकर मांग की धमकी देते रहते थे. बेटी को जान से मार देंगे और हमेशा प्रताड़ित करते रहता था. साथ ही समय समय पर मारपीट करते थे. आज उनके ससुराल वाले दहेज के से सूचना दिए, दहेज के फोन पे सूचना दिए कि मेरी बेटी को का देहांत हो गया. मैंने मेरे द्वारा सूचना पर सभी परिवार वाले ग्राम मानपुर थाना सचिव सर को देखने के लिए उनके पति महेश कुमार के ससुराल ग्रामों के द्वारा गए तो वहाँ उनके सरिता देवी के दहेज के रूप में हत्या कर दिया. The lordship, no doctor had not given any opinion regarding cause of
Opinion was just my lord.
Or the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that the marriage was solemnized in the year 2023 and the wife of the petitioner was found dead. He submits that the death was natural. And the doctor has not given any opinion with regard to the cause of death. And the petitioner is in custody since 5/5/2025. 5/5/25 कब से? Okay. Custody since 8/4/2026.
8/4.
The learned counsel for the state has opposed a prayer for bail and has submitted that there is direct allegation of demand of dowry in the FIR itself. And the wife of the petitioner was less than 25 years of age and died in matrimonial house. The cause of death, the doctor has kept opinion reserved till his trial report. After hearing the learned counsel for the parties and considering the direct allegation made in the FIR itself regarding demand of dowry and torture, and the wife of the petitioner died in matrimonial home within 3 years of marriage. This court is not inclined to enlarge the petitioner to the constitution. It is always at this stage.
Item 13 DT.06.07.2026 of 2026.
Yes, petitioner.
It is alleged that the person was digitally arrested and amount of rupees 10 lakh has been distorted or defrauded from the government. After that,
Digitally arrested when?
yes, please.
When was he digitally arrested?
On 19 to 2026.
The money was recovered from your bank account?
No. I'm a SIM seller. I have sold the SIM which was used for the purpose of this digital apps.
SIM seller,
Yeah,
you must be having some license.
I don't have any license, but I'm a SIM seller. I have sold 1,000 of SIM. And I have no criminal antecedent. This is for the first time.
You see, if you run a shop, there has to be something that you are running a shop and you are just a shopkeeper.
That
What do you mean SIM seller?
Nothing incriminating has been recovered from the car.
He had POS है POS मशीन उपयोग करते हैं POS मशीन
POS machine point of sale कहते हैं उसको, point of sale SIM का point of sale. That is what POS machine.
And this SIM was used for the commission of
Yes.
bills.
This is the only.
Let us see the case study.
There is no.
We'll see the case study. The learned counsel for the state is identify the contract along with the criminal antecedent report of the cybercrime of the petitioner. Let the case study along with its exclusion report from the concerned court. Post this case on 29th of July. Contract agreement 5/27.
Item 14, BS 6188 of 26.
Case of cybercrime.
Since when are you?
16/5/27 custody years.
16/5/26. Charge sheet signed.
Submitted
Not yet.
20-25 days minutes. Date will fix minutes in the next one.
No,
And I
not
will
at the
fix
stage
minutes.
of investigation.
Then I permitted to withdraw at this stage minutes.
BA number 6188.
And what is agreement to account of
The learned counsel for the petitioner submits that. He may be permitted to withdraw as the investigation is not yet over. Counsel for the state has no objection to the prayer for withdrawal.
And what is agreement to account of
That is always there. Since the learned counsel for the petitioner is permitted to withdraw this application.
Signed. Item 15, BS 6212 of 2026.
Yes, petitioner.
16 साल
Yes.
लड़की 16 साल minor.
उनको बहस करनी है.
Lots of victims' statement under section 180 BNSS has been recorded. And in that statement, she has categorically stated that her parents were forcing her to get married, and therefore she herself called this petitioner and asked him to drop her at Deoghar. So there is no inducement on my part also.
So where is the statement? You have to call for the statement of the victim. You have a copy of the statement of the victim.
Yes, Lordship, we have the case diary.
Case diary में
नहीं,
वहाँ
नहीं है
का statement नहीं है.
180 statement is there.
That is not sufficient.
Case diary may be called for Lordship if 183 statement
The-
has been recorded. We have no knowledge about that.
Please hold on.
Yes, Lordship.
The learned counsel for the state is directed to serve notice upon the informant of the case and file a counter affidavit. Charge sheet has been submitted.
No, Lordship.
Charge sheet में submit हुआ तो क्या ही करना? Investigation is going on. At this stage, I will not entertain this.
The case diary may be called for Lordship. If 183 statement in that also, if she has stated the same thing, then
The learned counsel has submitted that though investigation is going on, but the victim has not supported the allegation in a statement recorded under section 183 BNSS. Call for the statement of the victim recorded under section 183 BNSS from the concerned court. Counsel for the state is directed to file a counter affidavit by 20th of July, post on 22nd. Notice कर देंगे. And also the, एक second. The council for the state shall submit the up-to-date case diary to the learned court master on 20th of July, along with its enclosure, particularly the medical examination report.
Item 16, BS6216 of 2026.
Which is under section 70, subclause 2 of the BNS and section 6 of the POCSO Act. In this case, my lord, your ladyship,
The trial is on
yes, your ladyship, the victim and the victim's
out
mother
of,
has not supported the
just a moment, out of 9, 3 have already been examined.
The position of PW1 and 2 is on record. Victim and the victim's mother, they have not supported the prosecution.
They are hostile,
Yes,
both of them.
yes.
Let us see the FIR and then we'll come.
Page 17. May I read it? मेरा नाम इतना है, उम्र 14 वर्ष, पिता स्वर्गीय सचिन सच बिजुलिया रांची निवासी हूँ, मैं बिना डर भय के मटेरियल्स लाइन से आते हैं कि मैं कल दिनांक 12/10/2025 को समय करीब 12 बजे दिन में अपनी बड़ी बहन सचिन सच तथा अपने होने वाले जीजा जी अमित गुराव पिता नामालूम एड्रेस सच के साथ छोटका टोली में पहाड़ा यात्रा घूमने गए थे। इसी बीच मेरे जीजा के चचेरे भाई दीपक उराव अपने दोस्त वसंत उराव, आकाश उराव उनके साथ अन्य दोस्त वहां पहुंच गए तथा हमसे गुड़िया गुड़िया कर बात करने लगे। अंधेरा हो जाने पर मैं अपने होने वाले जीजा अमित उराव एवं अपनी दीदी से बोले कि चलो हमें यात्रा घुमा दो। तब मेरे होने वाले जीजा ने अपने भाई दीपक उराव को बोला कि मैं अपने दोस्त के साथ ले जाकर इसे यात्रा घुमा दूँ। तब मैं दीपक, वसंत एवं आकाश एवं उसके 5 अन्य दोस्तों के साथ मेला घूमने चली गई। कुछ देर घूमने के बाद मैं दीपक को बोली कि मुझे अपने होने वाले जीजा एवं दीदी के पास पहुंचा दो। इस बात पर दीपक बोला कि कुछ देर और घुमा लेते हैं, उसके बाद हम लोग चलते हैं। और जब अधिक रात हो गई तो हम जिद करने लगे मुझे अपनी दीदी जीजा के पास पहुंचा दो, तो ये लोग मुझे पहुंचा देने के बहाने खेत से होकर जाने लगे। तो कुछ दूर जाने पर मैंने बोला कि इधर से क्यों जा रहे हो? इस बात में उनके द्वारा बोला गया कि इस रास्ते से हम लोग जल्दी पहुंच जाएंगे। सुनसान और खेत होने के कारण मुझे काफी डर लगने लगा। तब मुझे कुछ गलत का एहसास होने लगा तो मैं भागने की कोशिश की और भाग कर नजदीकी सड़क पर आ गया। तभी दीपक, वसंत, आकाश और अन्य सभी लोग मुझे जबरन उठाकर सड़क से कुछ दूर राम मोटू स्थित एक करकट घर में लेकर गए। तो सबसे पहले आकाश ने ऐसा जबरदस्ती किया।
This what do you say, man?
This one of their direct allegation and
To direct allegation, the victim and her mother are declared hostile.
victim is
Yeah.
minor, but
Victim is minor, but she is hostile. The mother is also hostile. Who is the informant? Mother is the informant.
but FIR में लोग
Informant.
direct नाम दिए और direct
Informant कौन?
नमिया कुमारी victim है।
Victim ही। क्या करेंगे? आपको लगता है से आप conviction sustain कर लेंगे? DNA profile भी नहीं collect हुआ। Have you collected?
no man.
BA number 6216 of 2026. The learned counsel for the petitioner submits that the petitioner is in custody since
13/10/2025.
13/10/2025, and the victim and her
Next chapter.
and her mother have turned hostile. The learned counsel submits that there is, in such circumstances, the petitioner being enlarged on bail. The learned counsel for the state is opposed to pay for bail. I wish it does not dispute that the petitioner and as well as the victim as well as her mother have turned hostile. The impugn order further reveals that the SFSL report of the DNA profiling of clothes stained of the victim and the blood sample of the accused is available. The review order reveals that out of 9 charge sheet witnesses, 3 have already been examined. Counsel for the state is directed to procure the DNA report from FSL and produce the same in seal covered police. Post on 30th of July. Gang rape का case है.
Item 17 BA6218 of 2026.
वो जो भी एक withdrawal का order किए थे ना at the stage of investigation.
लास्ट वीक में मुझे बोले थे जल्दी फाइल लेकर मैं जो फाइल अब आ रहा है तो फाइल आता है लेकिन अब रोक दिए
थोड़ा सा कुछ इन्वेस्टिगेशन नहीं होगा तो हम क्या देखेंगे?
ये गलती हो गया था जब हम लोग टिकट हटा दिए थे लेकिन अब गलती वैसा
कोई
नहीं
बात
कर रहे
नहीं। एक बार चार्जशीट हो जाए तो आप आइए फिर से क्या होता है इन्वेस्टिगेशन?
एक लोग इसमें माफ कर दिया
नहीं बस नहीं यू कैन फाइट अगेन कोई बात
बहुत मुश्किल से मैटर्स मिलता है हम लोग
ऐसा तो नहीं
बहुत मुश्किल से आता है
नहीं देखिए आपको बात बता रहे हैं आई एम टेलिंग यू
एक चीज हम सर्टिफाइड
नहीं प्लीज अप्रिशिएट दिस एक इसका तो विड्रॉल का ऑर्डर करिए
I was in another court. I was of the impression that junior is appearing. It will be Delhi will be called for in August.
आप तो आ ही गए ना आई टेल यू
अगस्त में आ जाएगा 15-20 दिन में आ जाएगा चार्जशीट 2 महीना से ऊपर हो गया
सुप्रीम कोर्ट का ऑर्डर दिखाएं
हम उसको ही नहीं कर रहे
You see, the court is-
तब उसमें ऑर्डर कर दिया जाए विड्रॉ टू सम फाइल आफ्टर सबमिशन ऑफ चार्जशीट जो dismiss
एक ही बात है
नहीं एक मैटर्स गोस अदरवाइज बिकॉज़
ऐसा मेरे पास आएगा ना
नहीं आएगा आप ही के पास इसी के लिए हम बोल रहे हैं विड्रॉ टू रिन्यू आफ्टर चार्जशीट यही खाली कर दिया जाए वी हैव आल्सो स्किन सेविंग होता है कभी
और अभी बार से गलती भी ऐसे नहीं होती
we are trying to file only after 2.5 months so that charge sheet may come but withdraw after renew after
नहीं ऑलरेडी
withdraw खाली कर दिया जाएगा
ऐसा नहीं कर सकते it will not make any difference
request है कि it goes otherwise
it will not go otherwise
Item 18 BA6220 of 2026. Signed to be.
इसमें कोई एक्यूज का फिक्स्ड है 21 साल इसमें चार्ज फ्रेम सब
BA number 6220 of 2026. The counsel for the petitioner submits that the case of the co-accused in BA number 5149 of 26 is fixed on 21/7/26. The learned counsel for the state, Mr. S.K. Dubey, has joined online. Post is fixed on 21/7/26 along with BA number 5149 of 2026. The counsel for the state is directed to file a counter affidavit in this case. उसमें केस डायरी हुआ होगा
केस डायरी और ये हुआ है सब
इसमें एंटीसीडेंट आप इनका फाइल कर लीजिए along with the counter.
I have given this antecedent minute I was apprehended thereafter remanded in this case. That's only
Report.
एक लास्ट रिक्वेस्ट उसको करते हैं एक बार विड्रॉ करा दीजिए विद लिबर्टी टू रिन्यू
It is always there.
Item 19 BA6223 of
My lord, I am happy on behalf of the state.
Nothing for the offense under section 74, 126, 215, 352, 51, to BNS and plate of popular. And you see the FIR allotted, there is vague allegation in the FIR.
Investigation is still going on.
Yes, Your
क्या करना है? We will see it.
दिनांक 22/5/2026 रात्रि करीब 10 बजे पति पत्नी खाना खाकर बाहर सो रहे थे तथा मेरे घर के लोग शादी में गए हुए थे जिस कारण मेरी बेटी संजू कुमारी उम्र 15 वर्ष घर के अंदर सो रही थी। लाइट कट जाने के कारण दरवाजा खुला कर सो रही थी। इसी समय घर के अंदर से घबराई हुई आवाज के साथ एक लड़का का भी आवाज सुनाई दी।
तो मैं जग गया, फिर देखने के अंदर के दरवाजा बंद था, तो मैं बाहर से सिकड़ी, दरवाजा बंद करके आसपास के लोगों को बुलाकर दरवाजा खुलवाया और अपनी बेटी से पूछा कि क्या हुआ, साथ में कौन था। तो बताए कि हम नहीं जानते, पर एक लड़का छत पर गया है। तब जाकर छत से लड़का को पकड़कर लाए और मेरी बेटी
Caught on the spot.
कल योर लॉर्डशिप ये बोल रहे हैं कि बाहर से बंद कर दिए थे, लड़का कहाँ से गया। और
नहीं,
सिर्फ बोली गलत
मैं
कैसे
spot on the
छेड़छाड़
spot. आपका घर है, आपका घर नहीं है ना? You got caught on the spot.
एलिगेशन दिखा है गलत नहीं, नो स्पेसिफिक शी इज नॉट
क्या कर रहे थे रात को इनका घर?
स्पेसिफिक सेक्सुअल असॉल्ट के बारे में कुछ नहीं बोले। सेक्शन 7-8 नहीं बोला, इसमें ठीक किया जाएगा। गलत नियत से छेड़छाड़ कर रहा है, क्या छेड़छाड़ कर पनिशमेंट ही है सेक्शन 7-9। अब ये भी देख लीजिए कि
The counsel for the state is directed to serve notice upon the informant of the case and file a counter affidavit. Let the statement of the victim recorded under section 183 DNC be called for from the concerned court. Investigation अभी चल ही रहा है।
एक बार केस करेंगे।
केस डायरी में क्या आएगा? इन्वेस्टिगेशन चल रहा है तो What will we get?
स्टेटमेंट में भी एक बार देख के बस
नहीं पता कि
इसमें विक्टिम
Poses
भी
case on-
इनका अलार्म,
sorry
इसमें विक्टिम भी कोई अलार्म रेज नहीं किया, फादर खुद से सुने योर लॉर्डशिप, तब वो जाके बाहर से लगा।
Poses case on 30th of July. The counter affidavit will be filed by 27. The counsel for the state is directed to submit the up-to-date case diary along with its enclosure to the learned postmaster on 27 June. On the spot पकड़ाने में थोड़ा सा दिक्कत।
On that spot.
चलिए देखते हैं स्टेटमेंट देखते हैं, कोई प्यार मोहब्बत का कहानी होगा तो सुनते हैं।
Item 21 BA 6230.26.
Registered under section 69 FIR is at page number 5006. Date of occurrence is 2020. 2022 का date of occurrence. FIR was lodged on 16/4/2026. Near each university. Page number 15 is the
State, what kind of allegation is this?
no.
अचानक पढ़िए पढ़िए
jumped in the boundary wall.
और उसको उठा के बाउंड्री वॉल से लेके चला गया, अब जबरदस्ती उठा के। और तो enormous delay in filing the FIR. होता है मेजर।
Yes.
Or the learned counsel is appealing on behalf of the parties. The learned counsel for the petition submits that, as per the FIR, there is an allegation that on the pretext of marriage, the petitioner has committed rape upon the victim and in the FIR, a reference has been made to an incident of 2022, and it is alleged that the petitioner crossed the boundary wall and entered
Of the
hostel and took away the victim by jumping the boundary wall and committed rape upon him. The learned counsel submits that the petitioner is in custody since
6/5/26.
6/5/2020.
Just tell me submitted.
And charge sheet has already been submitted. The learned counsel for the state has opposed the bail for bail. However, the aforesaid submissions made by the petitioner on the basis of the FIR itself has not been disputed. After hearing the learning counsel for the parties. And admittedly, the petitioner and the victim are major. And the incident is of the year 2022. Case has been lodged in 2026. The petitioner is getting that.
Item 22, BA 6234 of 2026.
साइबर क्राइम इसमें कॉग्निजेंस भी हो गया है 10/6/2006 के क्रिमिनल एंटीसीडेंट नहीं है पारा 6 में लिखे हुए हैं और इसमें एलिगेशन है कि ऑन दिस सीक्रेट इंफॉर्मेशन
Custody
पुलिस has said the petitioner
Custody.
कस्टडी को 14/4/2026 कॉग्निजेंस 10/6/2026 कोई क्रिमिनल एंटीसीडेंट नहीं है पारा 6 में लिखे हुए हैं और सिर्फ एक मोबाइल जो है मेरा मोबाइल है वही रिकवरी चूंकि हमको घर से अरेस्ट हुई तो वही मोबाइल रिकवरी
The learned counsel for the state is directed to seek instructions and find account. Indicating the criminal antecedent report of the petition. Cyber offense matter. Let the case ID along with its enclosure be called from the concerned. Post on 29. The counter affidavit will be filed by 27.
Item 23, BA 6240 of 2026.
At the request of the counsel.
Item 24, BA 6244 of 2026.
The case has been registered under section 74, 75. The main section is 12 of the postcode. So the FIR is at case 22, very short FIR. Can we go through yours?
Let's read it.
Very good.
Yes.
Second निवेदन पूर्वक करना है कि ममता देवी she is the informant. पति सोहन
Please do not take the names, right?
अच्छा जिला हजारीबाग का स्थायी निवासी हूँ। आज दिनांक 21/5/26 को जब मेरी बेटी कटवा स्कूल से छुट्टी होने के बाद वापस लौट रही थी तो लौटने के दौरान संदीप कुमार से ये पिटीशन पिता सुनंसो कटमा सदी पुराना पंचायत भवन के पास रास्ते में मेरी नाबालिग बेटी नाम हम नहीं पढ़ रहे उम्र 14 वर्ष का हाथ पकड़कर छेड़छाड़ करने लगा और बोलने लगा कि चलो तुम मेरे साथ एक बात बताएंगे। उसके बाद मेरी बेटी अपने सहयोगियों के साथ मिलकर जब उसका विरोध की तब संदीप कुमार सिंह वहां से भाग गए। सब्सिक्वेंटली नोट देयर आफ्टर द लास्ट पैराग्राफ इसी साल रामनवमी के दिन 10 दिन पहले भी संदीप कुमार सिंह ने मेरी बेटी का मोबाइल से मैसेज करके दबाव बनाया था तुम मेरे से बात करो किसी से डरो नहीं। तो उस समय मेरा बेटा संदीप कुमार सिंह को मैसेज करके डांटा था उल्टा इसके साथ मारपीट हुआ। इसके बाद उसके घर जाके इसकी शिकायत उसके पिता से करके दोबारा इसकी गलती न करने का आदेश दिया। So there was some enmity going on in between the brother of the girls and this petitioner. Our allegation in the FIR is that I have catch hold the hands of the. I don't have any antecedent. Not I am in jail from last 1 month now. कोई antecedent नहीं हमारा, which is happened from the FIR itself. Paragraph 17 I have mentioned about the criminal antecedent. हाथ पकड़ने के लिए एक महीना तक जेल में अंदर जबकि ये FIR में बोलता है कि इसके बेटा से इन्फॉर्मेंट के बेटा से इसकी लड़ाई हुई थी। फॉल्स
कस्टडी में कब से?
कस्टडी में तो 23/5/2026
कब?
The victim has supported the case under the statement under section
The allegation is only that he tried to
And he
operate
is
the
only
mosque.
14 years, he is 27 years old. Your Lordship. He is only 14 years.
That's why this is possible.
Enmity was apparent from the FIR itself.
He was making pressure on her.
The council, आपका तो चार्जशीट अभी नहीं हुआ,
Charge hopefully
नोटिस करते हैं तब तक हो जाएगा
22/5 को
नोटिस कर
22/5 को
लेकिन उसको नोटिस कर देते हैं, तब तक चार्जशीट कब से कस्टडी है
23/5/2026 कोई है नहीं अननेसेसरी हार्डन क्रिमिनल्स के साथ जेल में रहेगी एक तो भी केस नहीं एक्सेप्ट दिस हाथ पकड़ लिए लड़की का इसके लिए 1 महीना जेल में दैट्स एनफ आई थिंक सो वो भी सही है कि गलत है लड़का उनके भाई के साथ लड़ाई हुई हमारी दैट इज आल्सो अपरेंट फ्रॉम
number
देयर
6244 of 2026 heard the learned counsel appealing on behalf of the parties. The learned counsel for the petition submits that the petitioner is in custody since 23/5/2026. And as per the FIR itself, the petitioner was alleged to have grabbed the hand of the victim and took her towards the motorcycle.
No.
Dragged towards her towards the
छह सात कहने लगा बोलने लगा चलो तुम मेरे साथ एक बात बताई दैट्स ऑल मोटरसाइकिल में रनिंग है सब्सिक्वेंट स्टेटमेंट आया होगा एफआईआर में नहीं है सर
What did he take a statement?
Let the statement of the victim be called for from the concerned court. Also, for the state is directed to serve notice upon the victim and file a contract. Post this case on 29, the contract will be filed by 27. उस दिन देखते सुन के कुछ कंडीशन लगा देंगे कुछ कंडीशन लगा देंगे 15 दिन का मान लो मुझे
appearing item 25 DT.06.07.2026 of 2026
petition.
In this case, the charge has been claimed under section 76(2)(a). This is at page number also 30. Also, in this matter, prosecutrix has alleged that both were in an active relationship since 2021, and she has filed a complaint case in 2023, and thereafter FIR is lodged. Petitioner is major aged about 39 years of prosecutrix is major aged about 39 years of their losses, and both were in an active relationship. That's relevant. FIR starts from page number 21. घटना का दिन तिथि समय व स्थान तिथि 3 जनवरी 2021 ईस्वी से
पेज नंबर 27
21 इसमें घटना का समय लिखा
आपका तो बीच में पेजेस ही गए 21 it's a complaint case.
हाँ कंप्लेंट के बाद में FIR तिथि है 3 जनवरी 2021 ईस्वी से दिन रविवार से लगातार दिनांक 18/8/2023 रोज शुक्रवार ग्राम
डेट ऑफ कंप्लेंट क्या है 2023
यह कि परिवादिनी के पति का आकस्मिक निधन हो गया है तथा परिवादिनी अपने बच्चों के साथ अकेली अपने घर में रहती थी। यह कि मेरे गांव का मनोज गंगाली घटना के दिन गंगालाल मुर्मू व्यक्ति को लेकर घर आया तथा कहा कि इसका पति मर गया है। यह पटना में एनटीपीसी में काम करता है। यह आपका तथा बच्चों का पढ़ाई लिखाई व अन्य खर्चा देगा। इस प्रकार का प्रलोभन मुझे मनोज बंगाली के सामने गंगालाल मुर्मू ने दिया। यह कि पुनः उसी दिन शाम में मेरे घर गंगालाल मुर्मू आया तथा कहा कि शाम का समय है
मैं कहाँ जाऊंगा, मैं आज रात में आपके घर में रुकूंगा। यह कहकर लिंगालाल मुर्मू मेरे घर में रात्रि में रुक गया। यह कि तथा कथित घटना के दिन वह रात मेरे पास आ गया तो मैं बोली कि मेरे पास क्यों आ गया, रात्रि में कोई देखेगा तो मेरा इधर चला जाए। यह कि इस पर गंगालाल मुर्मू ने कहा कि मैं आपसे शादी करूंगा तथा मेरे विरोध करने के बावजूद मेरी इच्छा के विरुद्ध उन्होंने मेरे साथ बलात्कार कर लिया। यह बात मैं सुबह में अगल बगल के लोगों को बताया, तब अगल बगल के लोगों के द्वारा गंगालाल मुर्मू को गांव के लोगों ने भी पकड़ा तथा गांव वाले कहा कि हम मुन्नी देवी से शादी कर लेंगे तथा इसके बाल बच्चों का भी सारा खर्चा मैं दूंगा। यह कि इस प्रकार यह बीच में मेरे घर जब भी मौका मिलता था आता था तो मेरे साथ
Yes, what do you say?
On the very first instance, he has done it against her.
Subsequently, it seems that there was some talk of marriage and custody comes.
I was occupying custody since 12/5/2026. Earlier Lordship, I filed an anticipatory bail application which was rejected, which is annexed by the next Lordship.
12/5/26.
Yes, Lordship.
The learned counsel for the petitioner submits that the case was lodged on the basis of a complaint case and it has been alleged that the co-villager introduced the petitioner to the victim and presented that the petitioner is an employee in NTPC Farakka and would take the responsibility for the education and maintenance of her children. And consequently, the accused came to the informant's house and stayed there during the night and assured the petitioner, assured the victim that he would marry him. And subsequently, he established physical relationship, and on 27/6/23, the accused refused to marry. The learned counsel submits that the charge has already been claimed on 25/5/2026. And earlier, the petitioner had moved this court in anticipatory bail application, which was rejected. Compromise भी हो गया है? ऐसा anticipatory bail में
उसमें उस समय हो रहा था लॉर्डशिप, अभी नहीं।
compromise का चांस है तो नोटिस कर देते
नहीं, अभी तो नहीं।
The learned counsel for the state has opposed the claim for bail. However, the reported submissions made by the counsel for the petition is not in dispute. After hearing the counsel for the parties and it appears that there was some element of consent. The petitioner is directed to the national.
Item 26 BS6251 of 2026.
Against us, charges have been submitted under section 300. In this case, Lordship,
सारा witness examine हो चुका है, अब क्या बचा? Next step
मेरे against में नहीं, मेरे against में just charge it file. Or other person have already been granted bail by coordinate principles, which I have made an annexure and
आपका ट्रायल नहीं चल रहा है अभी,
charge it just.
आप आगे बढ़ो।
Surrender में खुद किया।
अच्छी बात है, but where your trial was split.
हाँ जी सर। उसमें वो सेवना कोई दूसरा बेल हो गया कोऑर्डिनेटर से annexure 2 में लगाया मेरे अगेंस्ट में 354 में लोग
आप नेम डिक्यूज
नेम victim is no more lord.
Victim died of what?
Victim was murdered by her husband. Husband is in custody.
What is the death? उन लोगों का तो बाकी लोगों का हुआ है, उन लोगों का तो काफी दिनों से बाद हुआ है, क्योंकि उन लोग पहले से ही कस्टडी में थे।
उन लोग को 1 महीना में 12-19 में victim was died.
1 महीना में नहीं बेल हुआ, 3/7/24 को बेल हुआ है, कस्टडी था 14/8/23।
अजीज मियां का कस्टडी था 14/8/23।
14/8/23 बेल हुआ उनका 3/7/24। 1 महीना में तो नहीं हुआ।
और सिर्फ मैं उन लोग का कैसे
FIR आपके अगेंस्ट पे किस पे चार्जशीट
354
कहाँ लिखे और कहाँ मिलेगा?
12 में
आपका
12-14 में लिखे हुए
कस्टडी कब से?
5/5/2026। आपने स्टैंड नहीं हुआ
चार्जशीट हो गया, चार्जशीट अंडर सेक्शन
चार्जेस
अंडर सेक्शन 354 चार्ज फ्रेम तो नहीं हुआ। इंटरव्यू नोटिस से तो नहीं पता चल रहा है क्या चीज में चार्जशीट है।
केस डायरी के 59 में
आपके ऊपर एलिगेशन अलग है।
यस
पढ़िए
मेन एलिगेशन
मकसूद मियां
लोग का जजमेंट डायरेक्ट और इस संविधान निवेदन है पूर्वक कहना है कि मैं रिसर्चन से जाके कहना है
ये करीब 12 बजे रात को यहाँ से पढ़ी, घर से बाहर निकली।
मेरे पति कुछ दिन पहले मजदूरी के काम करने बाहर चले गए थे और मैं घर पर अकेले रहती थी। इसी क्रम में दिनांक 6/8/23 को खाना पीना खाकर सो गई थी। समय करीब 12 बजे रात को मैं घर से बाहर शौच करने के लिए निकली। इसी क्रम में ग्राम मियाँ, हुसैन मियाँ, अजीज मियाँ, कैलू मियाँ, अदर सातों ग्राम कुंदन थाना लावालौंग जिला चतरा में मुझे घेर लिया और बोलने लगा कि आज तुमको नहीं बैठने देंगे और सभी साथों ने मेरे साथ शरीर में इधर उधर छूने लगे और सहनाने लगे। और आलम मेन आलम उसका बेल हो गया। बोधवा अंसारी को बोले कि इसको लेकर बोधवा को बोले लेकर गांव आओ। इसके बाद आलम को बोधवा अंसारी पिता कैलू मियाँ ने हमको पीछे से पकड़ लिया, हमको भी दबा दिया और बोला कि चाकू से जान मार देंगे।
heard the learning council sitting on behalf of the parties. The learning council by the petitioner submits that he is in custody since
5/5/2026.
5/5/2026 and charge sheet has been submitted under section 354 of IPC. He has further submitted that the co-accused who are facing crime for offence under section 376D/506 and 34 IPC have been enlarged on bail by the following judges. The learned counsel for the state, though has opposed the claim for bail, but does not dispute that the charge sheet against the petitioner has been submitted only under section 354 IPC. After hearing the learned counsel for the parties and considering the fact that other co-accused considering the fact that charge sheet has been submitted under section 354 IPC and other co-accused have been enlarged on the petitioner is admitted.
Item 27 BS6252 of 2026.
Petitioner has been supposed to
Item 28 BS6255 of 2026.
Case registered in section 62 and 64 of BNS, section 8 and 10 of
since when are you in custody?
I am in custody since 23rd of May 2026.
अभी
Age
तो
by
investigation तो चल ही रहा है, अभी क्या
investigation चल रहा है.
अभी क्या आएगा अभी
She has
investigation
not
होना है?
supported. As per my information, Lordship, I have perused the case diary.
केस डायरी अभी कहाँ से अभी तो इन्वेस्टिगेशन चल ही रहा है.
हाँ, बेल में आया वहाँ तब भी ट्रायल कोर्ट में आया.
आप कब से कस्टडी में है अभी तो इन्वेस्टिगेशन चल ही रहा है.
23/5 से है. ये केस में एलिगेशन ये है, केस तो स्पेसिफिक एलिगेशन का है कि अटेम्प्ट भी है, लेकिन प्रूफ फैक्ट ये है कि सांप आया घर में, वो लड़की चिल्लाने लगी, हम रोड पर थे, घर में घुसे, तब तक चाची देख ली और उसके बाद पूरा एफआईआर हो गया. और उसकी 183 बीएनएस में लड़की यही स्टेटमेंट दी है, घर में सांप घुसा था.
183 cases.
हाँ,
She has not made any allegation against
No. ये इसमें भी केस
the learned counsel for the petitioner has submitted that though there is direct allegation against the petitioner in the FIR, but the victim has not supported the prosecution case in a statement recorded under section 183 BNSS and no allegation has been made against the petitioner. The investigation is still going on. Let the statement of the victim be called for from the concerned court. Counsel for the state is directed to serve notice upon the informant of the case. Post this case on 22nd, the counter affidavit and by counter affidavit will be filed by on 20th of July. 22 तारीख को सुनेंगे along and produce a medical examination report of it.
A medical examination she has refused. She has refused for medical
Yes.
examination.
The learned counsel for the petitioner has submitted that victim has refused for medical examination.
Along with her mother.
Along with the
Mother.
mother का भी होना था क्या?
नहीं, मदर वहाँ गई लड़की के साथ, वो मेडिकल ऑफिसर के आगे लीक करके दी कि हम मेरी बेटी नहीं
वो
कराएंगे.
बताएंगे.
हाँ.
183 का स्टेटमेंट आने.
हाँ, ठीक.
Item 21 BA6259 of 2026.
Plus the allegations of cyber fraud, plus the petitioner was arrested on 26/3/26 and is in judicial custody since 27/3/26. Whereas the charge sheet was submitted on 22nd of June 26 and the cognizance was taken on 23rd of June. Whereas today is the date fixed, whereas as have been informed for probably framing of charges. Because the petitioner has criminal antecedents under the Negotiable Instruments Act, Section 138, and with the Payments Act of the bank. Is a loan defaulter. That is the antecedent.
So that is a separate thing.
There is no.
Your bank account has been used.
I must say, the bank account was a non-performing asset. It was a mule account. No transaction was carried. Now, what has been happening over a period of time is that mule accounts are designated, people are approached, they are lured for the commission, the money comes in by the third party, the crime is committed by the third party. Now, this is a case where accused himself is a victim. His account has been used, no dispute about it.
Accused fell for the greed.
I completely bow down. My lords have absolutely put it in the right words. He fell for the greed. But if my lords would read the FIR, there is no allegation that I was the one who carried out the conduct of digital arrest. There is no allegation. Certainly, my lords have rightly said.
These kind of crime are all organized crime. If we see, you cannot. The person who is lending his bank account for commission of an offence.
No, that's an offence. I must say, as an officer of the court, I must say.
Crime. Everybody is equally responsible.
Yes, absolutely. Maharaj said absolutely correct. As an officer of the court, I must say this is an offence lending the bank account and the credentials. But the fact remains there is no allegations as against me that I am the one who carried out digital arrest. I am the one who utilized the money because the money came transferred to a third account, maybe running into 400 different accounts. I am a resident of Ranchi.
How is it that you are not aware what all is happening to your account? This is absolutely unbelievable.
What happens? Whenever these kind of people are lured, not only the credentials are taken, Malots are aware that nowadays, whenever any transaction is carried out, the OTP generated transactions are carried out. And all these people, they fell for the greed, they hand over their phone also to the people concerned.
We can't deal with it. Not at all. I'm not inclined.
That's
the
huge
amount.
3 crore, more than 3 crore.
More than 3 crores.
1.89. 3.09 the transactions were carried out, the disputed amount is 1.89.
I'm not given bail to even 1%.
No,
these kind of offences.
Subject to Manoj's permission.
And what further thing you need from me, just
can I be because there is no allegation that I have never cooperated in the investigation. I am a local resident. I have a property.
It's an open and shut case. There is so much against you. Banking transactions, through banking transactions, this fraud is being committed.
Yes.
So your cooperation, non-cooperation doesn't have much bearing in this.
For the fact remains, the investigation complete. Charge sheet has been submitted. Cognizance has been taken. Now, I have to face a trial.
You have been arrested on the basis of NTW, right?
Yes, please. There is no summon prior there to me. I cannot. And I was arrested out of income tax office from the just I was coming out of the income tax office.
And so many people are approaching you for this purpose.
No.
It's not just one person.
No.
You met Mr. Ali, Mr. Zakir, and then you went to Kolkata, and this is all is there. You have mentioned it in your petition itself.
Yes, Milot. Whatever was the fact, I was lured. That's the fact. I was lured.
Mr. Pasadi, I have not given bail to even one.
Can I make a fair submission?
I'm being fair and let me be fair to you.
No, can I? Subject to. The fact is that there is a dispute of 1.89 crores. There are two property I had purchased in the year 2022 and 2023. We are valuing, I had taken the instructions. The property is valuing approximately 6 crores. I have a bank liability of 3 crores. No. What I am saying is, let the property be attached.
That is not sufficient. BA number 6259 number 26. However, the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner submits that the NP account of the petitioner has been utilized and for the commission of the alleged offence, and the petitioner is not directly involved in the alleged offence. He has also submitted that the petitioner is a victim of the circumstances. He is in custody since
Minutes 26/3/26.
2026. Charge has been.
No, Minutes, I am not aware charge has been framed or
Charge sheet has been submitted
on 23rd of June, Minutes.
23rd of June 2026.
And the same day the cognizance has been taken.
And the same day cognizance has been taken. The learned counsel for the state has opposed the prayer for bail and has stated that
He himself admitted that he provided the bank account for the cyber.
Yes. It is not in dispute that the bank account of the petitioner was provided by the petitioner himself which was utilized for the purposes of commission of offence, and there are transactions of some total of rupees 1.86 crores in the account of the petitioner, through the account of the petitioner.
Minutes, only one thing.
After hearing the learned counsel for the parties and considering the direct allegation against the petitioner, and that the bank account of the petitioner is alleged to have been utilized for commission of cyber offence.
There are also complaints of cyber fraud in the portal.
Sorry, and there are numerous complaints of cyber offences against the account of the petitioner. This court is not inclined to enlarge the petition on the
There's only one thing, if my notes may just indicate that all the criminal antecedents pertains to only negotiable instruments. Which I made
I
as
haven't mentioned about any criminal antecedent. Criminal antecedent is basically to find out the veracity of the person.
Yes.
So, anybody who is in commerce, दो चार NIF का केस तो चलता ही रहता है.
as well.
Item 30, BA 6262 of 2026.
FIR registered under section 96/64 2M of the BNS and 4 at POCSO Act. But there was a love affair between both the parties. It is alleged that the victim has talking with the petitioner on the pretext of marriage. May kindly have a look at FIR page 15. Really?
Statute हो गया?
हाँ चाचा
Statute.
There is delay in lodging the FIR.
The learned counsel for the state is directed to serve notice upon the informant of the case that the statement of the victim recorded under section 183 BNS be called for from the concerned court, along with the case diary and its enclosures, including the medical examination. Post on 23rd, counter affidavit will be filed by 20.
Item 31, BA 6267 of 2026.
This is application for grant of regular wage. The offence alleged under section 304B of the Code of PC. Earlier, by order dated 9/2/2026.
Sir, only one witness is to be examined. Only one witness is to be examined.
But the
Out of as many as 10 prosecution witnesses have been examined, out of 11.
Out of 17, only 11 have been examined.
ये जो पेज नंबर 62 में है,
Oh, that is
आप husband हैं? You are the
this
husband.
is also happened, the submission was made. It is happened from page 61. That the out of 17 witnesses, I have also stated, 11 have been examined. I have understood the positions of 11 witnesses, and that it appears that PW 11 was examined. on 5th April 2025. Now, Lord, we are in
So we will.
July of 2026.
So we will expedite all the witnesses, not the husband. And
I
it
am
was
having
earlier
no doubt.
rejected also.
I am in jail custody since 15/11/2020.
It was earlier rejected also.
It was earlier rejected. I have stated.
Yes. For the learned counsel's opinion on behalf of the parties.
But the trial is going on in Excel
We will आप चिंता नहीं करो, आप produce करेंगे ना witness? कुछ आपका FSL वगैरह है क्या?
जी.
FSL का रिपोर्ट है?
नहीं, FSL का रिपोर्ट नहीं है, but the witnesses have been examined.
We will see that अगर FSL का होता है कभी-कभी ट्रायल इसीलिए रुक जाए.
नहीं, FSL का कुछ नहीं है. इसलिए कि doctor who has been examined at PW10, they also stated that this is the case of suicide. No doubt, this is a case of 304B. And in the FIR, it has been alleged that the deceased was murdered and thereafter dead body was hanged. But that is not being corroborated by the medical evidence. The only thing is that the expenses trial. I am in jail custody since 15/11/2022. The charge was framed on 25/7/2023, 3 years ago. And thereafter, the witnesses have been examined. I have understood this, all the deposition of the witnesses. The doctor was examined PW10 on 6th February 2025. The IU has been examined. Can you see some paragraphs of the
Sir, आपका जब पहली बार bail reject हुआ था on 9/2/2026,
Yes, the same thing, same
situation. We will expedite it. For the learned counsel's opinion on behalf of the parties, the petitioner being the husband is facing trial under section 303/4 of IPC. The learned counsel for the petitioner submits that the bail application of the petitioner was rejected on merit earlier in VA number 11921 of 2025, dated 9/2/2026, and he's in custody since 15/11/2022, and there is no much progress in the trial. The charge was framed as on 25/7/2023. The counsel for the state has submitted that out of 17 witnesses, 11 have already been examined, and the remaining witnesses to be examined, out of the remaining witnesses to be examined, many of them would be the official witnesses. होगा ना official witness?
Official witnesses. जो IU examined हो गया तो official witnesses. The IU was examined on one thing or the
After hearing the learned counsel for the parties and considering the serious nature of allegation and the bail application of the petitioner having been rejected earlier, this court is not inclined to enlarge the petitioner on bail. However, there can be no excuse on the part of the state not to produce the witnesses before the court. Counsel for the state is directed to ensure that the remaining witnesses are promptly produced before the court. Counsel for the state is directed to communicate this order to the SP of the concerned district and also to the director of prosecution to ensure compliance.
Let me indicate one thing, that for last 1 year, no witness has been produced by the court.
I have recorded that. That is why I am asking.
Item 32, DT.06.07.2026.
Same story. The investigation is going on. At this stage, the counsel for the petitioner seeks permission to withdraw this application.
Sign for the under heading for admission, item 33, DA.1190 of 2026.
Commercial offense under section 364(1). Informant is sister of the victim, Your Lordships.
Yasin is a person of ensemble.
Ensemble इससे उनका 83 का स्टेटमेंट भी रिकॉर्ड है हुआ, इस वजह से ये स्टेटमेंट है Lordships. इसको सर्टिफिकेट और ऐसा कुछ नहीं दिखा रहे हैं, लेकिन बट बिकॉज ऑफ हर स्टेट ऑफ माइंड उनका 83 का स्टेटमेंट रिकॉर्ड दे हुआ.
She was found in a naked condition.
So her mother came to ये petitioner का चप्पल और मोबाइल डीलरशिप वहाँ पे छूटा हुआ था.
Also recovered when she was found in a naked condition. From the place of occurrence.
Yes, but medical में कुछ भी आया नहीं क्योंकि there is a delay of 5 days in lodging of the FIR. All the witnesses have been examined in this case.
All witnesses have been examined. तो क्या चल रहा है, क्या स्टेज है इसमें? ये मतलब आर्गुमेंट
3 and 30 yes sir 13 and 13 का स्टेटमेंट भी रिकॉर्ड हो गया. आज का डेट फिक्स था सर.
over the learned council's appeal on behalf of the parties. The learned council for the petitioner has submitted that the petitioner is in custody since
18th August 2025.
18/8/2025. And the statement of the victim was also not recorded, could not be recorded under section 183 BNSS as the victim is of unsound mind. The learned counsel for the state has opposed a prayer for bail and has submitted that the victim was found in a naked condition and the mobile phone and the speaker of the accused was also recovered from the place of occurrence. Upon a query of the school, the learned counsel for the petitioner has submitted that all the witnesses have been examined and today is the date fixed for recording of the statement.
नहीं statement record के argument की लॉजिक.
Today is the date fixed for argument. After hearing the learned counsel for the parties and considering the fact that there is direct allegation against the considering the nature of allegation and the trial is apparent, the school is not inclined to enlarge the petition on bail constitution.
Item 34, DA.11.760/2025.
Counsel for the petitioner seeks permission to withdraw this bail application.
Sign 21. Item 35, DA.3891/2026.
The offences as alleged in this case, several sections have been alleged, but the charge sheet is submitted under Article 366 IPC and 376 IPC. The total sees the first information report that is based on the complaint which comes to the 156(3). It is alleged by the verdict of the victim that she was eloped by the petitioner, she is a married lady, and the victim was subsequently examined under 180. But she says that she categorically states that she has been affair with the petitioner and they live together in one place for 2 months. And later on she married to someone else.
What is the name of the petitioner?
The name of the petitioner is Vishnu Sharma alias Vishnu Swarnakar.
Yes, madam, you read the statement. Petitioner is a neighbor of the victim.
Yes.
Custody?
It's been in custody since 25 से 26, 25/1/26.
What the learned counsel secretary on behalf of the party, the counsel for the petitioner submits that as per the as per the statement of the victim recorded under section 183 BNSS, the petitioner had allured the victim and her on the pretext of marriage and established physical relationship. And had taken her to Purulia. But ultimately left her. And now the victim is living with another person, namely Vikram Basu. The statement also, she has also stated that her husband has undergone separation. मेरा पति भी दूसरी शादी कर ली. The learned counsel submits that the petitioner is in custody since 25/1/26 and there is an element of consent. The learned counsel for the state has opposed the prayer for bail and has submitted that the petitioner established relationship on the pretext of marriage. After hearing the learned counsel for the parties, victim is a major.
Victim is the direct leader.
After hearing the learned counsel for the parties and upon going through the statement of the victim recorded under section 183 BNSS and charge sheet having been submitted, the petitioner is directed to be in.
Item 36, BA 4240 of 2026.
Earlier endorsement was pleased to offer that was valid along with representation. Only plus general allegations have repeated against the petitioner who is the mother-in-law. And the person report has given complete go-by of the case because the person report did not support the provocation case at all. Because there is the case of the petition remains suspected case of poisoning. And that is not supported in the case. And in the postmortem report also considered that neither that is stated in para 7 and para 8, no external or internal injury was found. And this petitioner is the mother-in-law who has got absolutely no concern with the amount of money, etc. But in the foot of the FIR, only person general allegation that. And from the postmortem.
Read the FIR, please.
Sorry. Page 18. 67. So, second, we can make a last round of the value. मेरी पुत्री नाम कल्याणी कुमारी है। यह मेरी पुत्री का विवाह पश्चात से मेरी पुत्री कल्याणी कुमारी से ससुराल वाली पति राजेश रविदास, सास कुंती देवी, ससुर देवी, संगीता देवी, पूजा कुमारी दोनों के पिता रवि रविदास, सभी ग्राम चुनलामू खाना पर तथा जिला हजारीबाग के द्वारा दहेज की मांग को लेकर शुरू से मेरी पुत्री को प्रताड़ित किया गया। जबकि विवाह वक्त मेरे द्वारा अपने सामर्थ्य अनुसार उपहार स्वरूप दान किया गया। इसके बावजूद मेरी पुत्री के ससुराल वालों के द्वारा शारीरिक और मानसिक रूप से प्रताड़ित किया।
क्या बोलना?
para 7 ने 8 में तो दिए
क्या है?
स्पेशल रिपोर्ट में इससे कुछ आया नहीं।
नहीं, और काउंटर में क्या बोले? इनके अगेंस्ट में क्या है? सास के अगेंस्ट में,
काउंटर
मदर इन लॉ के अगेंस्ट में क्या है?
वैसा पूछते हैं
आप
केवल ये
काउंटर में क्या है?
पोस्टमार्टम रिपोर्ट और स्पेशल रिपोर्ट।
कुछ नहीं है पोस्टमार्टम में भी।
पोस्टमार्टम रिपोर्ट में
Cause of
तो
death
बोला डेथ इज in this case in my opinion is due to poisoning.
Postmortem report में no injury has been found.
No external or internal.
No injury has been
No
found.
injury.
Heard the learned counsel appealing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since
1/1/26.
12/1/26 and is the mother-in-law of the deceased, aged
40 years.
Aged 40 years. And charge has been framed under section 80 with bracket 2. Charge has been framed. Charge has been framed under section 80 with bracket 2/3 with bracket 5 of BNS. The learned counsel submits that as per the FIR, it was suspected that the victim died due to poisoning. In the postmortem report, there is no external or internal injury on the body of the victim, on the body of the deceased, and a physical report has now been received, which does not indicate any poisoning. पोस्टमार्टम रिपोर्ट कहाँ पर है डायरी में? The learned counsel for the petitioner submits that the cause of death could not be ascertained. Counsel for the state has opposed the prayer for bail. However, the submissions made by the counsel for the petitioner is something dispute. After hearing the learned counsel for the parties and considering the fact that the FSL report also does not reveal any poisoning, the petitioner is eligible.
Item 37 DA.06.07.2026.
Registered under section 75-76, 64, 62, 191, 35 of BNS but after investigation, police has submitted charge sheet under section 75-76, 191, 351, 3 of BNS and 8 of the POSCO Act. As per allegation, petitioner tried to commit wrong with victim Melody. And when he fell, then he thrown the victim in well.
वहीं से रिकवर हुई।
हाँ, वो कहते हैं कि मेरे अंकल फिर आए तो वहाँ से फिर हमको निकालेंगे। But there is no medical report, madam, and she denied from medical, madam. It come in paragraph.
She medical में क्या होगा? Because she was not raped.
अगर 109 है हो तो इंजुरी रिपोर्ट तो चाहिए ना, तो इंजुरी वो डिनाई कर रही है तो इंजुरी रिपोर्ट ही नहीं जब है तो कैसे 109 सब सपोर्ट करेगा? 109 मतलब अटेम्प्ट टू मर्डर के लिए ये चाहिए
वो कह रही है
इंजरी रिपोर्ट कहते हैं मर्डर नहीं हो सकता।
अगर वो कह रही है कि हमको कुआं में धकेल दिया गया, उसको इंजरी होना चाहिए। और मेडिकल अगर वो डिनाई कर रही
She
है
was holding the brick and
हाँ वो कह रही है तो और वो उसके अंकल के स्टेटमेंट में आया है कि वो करा रही थी, उसको चोट था, ठीक है, तो उसका मेडिकल होना चाहिए 109, क्योंकि विदाउट इंजरी कैसे एस्टैब्लिश होगा कि उसको ग्रीवियस इंजरी था, सिंपल इंजरी था, क्या था।
Since when is she in custody?
He is custody number 24/10/2025.
The medical हुआ ही
नहीं, वो खुद डिनाई करती है, पैराग्राफ 22 वो खुद डिनाई करती है कि हम मेडिकल नहीं कराएंगे, मैं अपना मेडिकल जांच कराने के लिए सहमत नहीं। सेक्शन 8 is the sexual assault.
क्या बोलना है?
Witnesses at para 7, 8, 9 and 10. They have supported the prosecution case that she was recovered from the well. That is there, and the allegation of the victim is there in this.
Why didn't she go for any kind of medical? Some injury तो होता हुआ भी के
Yes, definitely.
कुछ खरोच कुछ तो
Para 22 she is refused.
For the learned counsel appearing on behalf of the parties, counsel for the petitioner submits that the petitioner is in custody since 24/10/2025, and it is alleged in the FIR that the petitioner tried to molest,
commit wrong, molest by section 8 sexual force,
applied force upon the petitioner to commit wrong, but when she raised an alarm, she was pushed into the well from where she was recovered. She was subsequently recovered. The learned counsel, as per the allegation, the learned counsel submits that the victim completely denied her medical examination, and if she was pushed into the well, she ought to have suffered some injury. The learned counsel for the state has opposed the prayer no bail. However, the purported submissions made by the counsel for the petitioner is not in dispute. After hearing the learned counsel for the parties and considering the custody of the petitioner is eligible to be enlarged on bail.
Item 38, BA 4264 of 2026.
By order dated 10th of June 2026, this diary was offered. This is a case under section 87, 352, 351, 3 and 3.
183 का statement नहीं
Yes,
आया है।
that is not at page 27 of the case diary.
Yeah, that is a counter affidavit.
Counter has been
Has
filed.
not been filed. On judgment. We've seen a statement on this.
Yes, yes.
Yes.
सुमन कुमारी सत्यन सर
नाम मत पढ़िए।
सॉरी सत्यन सर 4 साल से जब रहे थे, हम दोनों एक दूसरे से प्यार करते थे। हम उसे छोड़ना चाहते थे और बात भी करना बंद कर दिए, सब जगह से भूलकर भी कर दिए। पर वो लड़का ने मुझे ब्लैकमेल किया, उसने मुझे बोला चलो मुंबई में बोली नहीं जा सकती हूँ, मेरा बोर्ड एग्जाम है, और उसने मुझे बोला कि हम मर जाएंगे और भी बहुत तरह का बात बोला। तब हम बहुत डर गए और बहुत नर्वस हो गए। तब हम गुस्से से बोले ठीक है चलो मुंबई चलते हैं, तुम पहले जाओ, हम कुछ दिन बाद आएंगे। हम बोले कि अकेले नहीं जा सकते हैं, तो बहुत फोर्स किया। तो मेरा दिमाग में क्या किया, मेरा दिमाग किया जाना ये ठीक पहले उन्होंने मुझे फिर उसने मेरे घर से 2-3 दिन पहले फोन और कुछ पैसा दे दिए और बोला कि तुम जाओ हम आ जाएंगे। कुछ दिनों में फिर हम उसके बात मानकर चले गए मुंबई और वहाँ पहुँच गया। उसके बाद मैं एक दिन वेटिंग स्टेशन में वेटिंग रूम में रहे। उसके दूसरे दिन स्टेशन में पुलिस ने पकड़ लिया, पूछताछ करने लगा। मेरा 16 वर्ष होने के नाते कारण मुझे व्यक्तिगत में ले जाया गया। उसके बाद मेरे घर में फोन
कौन सा स्टेटमेंट पढ़ी? ये 183 का स्टेटमेंट।
No, madam.
पेज 27 में
He is stating statement recorded before CWC.
CWC के यहाँ पेज
183 में
Yes.
183
लेकिन कुछ भी गलत का तो कुछ एलिगेशन नहीं।
ऐसा नहीं।
But victim is
वो
minor.
पैरा 3 में बोल रही है कि पिछले 4 साल से
For last 4 years she was
संपर्क है, वो
having
बॉम्बे अपने से गई। और मेडिकल रिपोर्ट में भी कुछ नहीं है रिसेंट।
her children and councils appearing on behalf of the parties. वीडियो कुछ रिकवर हुआ? नहीं हुआ। एलिगेशन रिकवरी तो नहीं है। Are you sure?
Yes. Allegation है कि वीडियो बना।
काउंटर फाइल किए ना?
हाँ। वीडियो के बारे में नहीं।
Or the learned councils appearing on behalf of the parties. The council for the petitioner submits that the petitioner is in custody since
17th March 2026.
17/3/2026, and the victim has declared her age as 16 years
Yes.
while recording her statement under section 183 BNSS, and a student of class 10, and has stated that she was having relationship with the petitioner for last 4 years, and has also stated that she, at the instance of the petitioner, went to Mumbai. The learned counsel submits that though there is an allegation in the FIR that certain video clip was prepared, but no video clip has been recovered. Charge has been framed.
No, charge sheet has been submitted.
The learned counsel submits that the charge sheet has been
submitted on 12 May
submitted.
2026.
Counsel for the state has opposed the prayer for bail. However, the aforesaid submissions made by the counsel for the petitioner is not in dispute. After hearing the counsel for the parties and considering the statement of the victim recorded under section 183 BNSS, and the petitioner is just 19 years of age, the petitioner is eligible to claim last on bail.
Item 39 BA 4286 of 2026.
Earlier deleted from the permanent bench of the Honorable Court. It has been alleged in the FIR that the petitioner has enticed the daughter of the
That's
informant.
right. But only one witness is
Malice.
used to plead.
Malice.
What is the next date?
9/7. Malice. In this case, Malice victim has turned hostile. Malice. She has been examined as PW1. PW2, the informant Malice, mother of the victim Malice. She has categorically stated in paragraph 1 and 2 of her cross-examination that no any occurrence has been taken place in front of her Malice, nor she had put any signature in any paper Malice. And Malice, most importantly Malice, PW6, the sister of the Malice victim Malice. Malice, her statement is important Malice.
Only one witness is to be examined.
Malice, though that there Malice, but Malice admittedly even in the FIR Malice that there was a love relationship. Even the witnesses have stated कि वो भाग गई और इनकी बहन का स्टेटमेंट एक बार मैंने जो है
तो ये आपका earlier rejected है,
दो-
direct allegation है, आपका only witness we will ask him to examine.
21 साल का मतलब the trial court will prejudice if he will remain in custody, malas,
ट्रायल कोर्ट कैसे प्रेजुडिस
malas, that
ट्रायल
is,
कोर्ट ऐसे कस्टडी से प्रेजुडिस होता है क्या?
malas, even it is apparent, malas, that the PW1 malas has turned hostile, who is the victim, malas, PW2 has not stated anything, malas, even malas she appears to be major, even in the FIR her age has been stated at 17 years, but malas the statement of her sister, malas, paragraph 6, malas, PW6 statement of malas sister of the victim, malas, मैं ग्रेजुएशन की हूँ, मेरा जन्म तिथि दिनांक 16/9/2003 है, मेरी बहन मुझसे करीब 4 साल छोटी है, मीनिंग देयर वाई इन द ईयर 2007 शी वाज बोर्न, मतलब 25 में केस हुआ है, शी वाज 18, मतलब इवन मतलब वो अपने एग्जामिनेशन इन चीफ में बोलती है कि इस कांड की पीड़िता मेरी बहन है, यह घटना पिछले साल दिनांक 17/4/25 की है, अभियुक्त बिट्टू कुमार मेरे गांव का में काम करता है, किसी कारण से अभियुक्त मेरी बहन से दोस्ती किया और दोनों के बीच से में बातचीत होने लगा, अभियुक्त बिट्टू कुमार मेरी पीड़िता बहन
रिकवर कहाँ से हुई है ये?
मतलब फ्रॉम पुणे, मतलब एंड
विथ होम
दैट है नो ये मतलब
गोमो स्टेशन से
नहीं पुणे गए थे, पुलिस की थी और वो खुद अपने एग्जामिनेशन इन चीफ में बोली हम अपने दोस्त के पास
एज क्या है?
मतलब 17 इयर्स ऐसे बोल रहे हैं, ऐसे 18 इयर्स मतलब जो है उनकी बहन की स्टेटमेंट,
ऐसे कैसे बहन का स्टेटमेंट, इनका कोई होगा ना डॉक्यूमेंट?
मतलब उसके लिए भी PW7 का स्टेटमेंट देखा जाए, आईओ का स्टेटमेंट, मतलब उसमें
रिकवर तो आपके साथ हुई है ना?
मतलब ऐसा यहाँ तो कहीं
yes or no?
मतलब
she was recovered from Pune from with you?
But I'm not sure, मतलब
You are
that's
not
why I'm
sure.
not
इतना आप
making this
evidence का बात कर रहे हैं और you are not sure.
मतलब
इसीलिए एक witness.
She is recovered from Gomo railway station, not Pune. I have prepared one counter affidavit in compliance of order dated 10/6/2026.
PW7 का paragraph
Seven witnesses already examined.
और the learned
paragraph 14 और 15 बस PW7 का लिया जाए, मतलब
ऐसे यहाँ ट्रायल नहीं चल रहा है.
मतलब even he
आप
had not
बताइए ना आपका नेक्स्ट डेट कब है?
बस
कौन सा विटनेस बच रहा है?
9 तारीख
Which witness is to be examined? Who is the witness to be examined?
My lord, one witness
मामा
Mama.
सब here से कुछ भी नहीं है,
रामानंद मिस्त्री है, ये पागल हो गया है, नहीं दे सकता, रिपोर्ट हम लगाए, बोलता नहीं है, सुनता नहीं है.
कौन?
ये जो रिमेनिंग विटनेस रामानंद मिस्त्री जो है वो बोलता नहीं है, हम मुखिया का सर्टिफिकेट प्रिस्क्रिप्शन वगैरह लगा.
तो ऐसा ही
पागल होना एक बात है, बोलना नहीं है दूसरी बात. दोनों में से क्या है?
इसमें जो मिला है हमको उसमें पेज नंबर 9 देखा जा सकता है. ये आपका
ऐसा ट्रायल है कि जो बोलता नहीं है, मतलब उसका स्टेटमेंट रिकॉर्ड कर लिए हैं, जिसका 161 का स्टेटमेंट नहीं हुआ PW3, वो खुद बोलते हैं कि इस केस में आज पहली बार गवाही दिया हूं, इससे पहले मेरी गवाही नहीं गई है कहीं, जिसका 161 में रिकॉर्डेड नहीं उसको गवाही करवा है.
इनका मानसिक संतुलन
ये
ठीक नहीं.
मुखिया सर्टिफाई करेंगे मानसिक संतुलन सही नहीं है.
उसकी पत्नी भी लिख के दी है, अब डॉक्टर
आप विटनेस प्रोड्यूस करिए, दिमाग मत खराब करिए. पत्नी बोली है और ये बोले हैं, कोर्ट में जाएंगे. हाँ, पत्नी बोली है मानसिक संतुलन खराब. Is he admitted in some hospital? You want to produce this witness or you don't want to produce this witness?
He is under treatment from
Where under treatment?
Dr. G.N. Singh Dhanbad.
Who is he? He's a psychiatrist.
Page number 12. No.
Then?
Consultant physician.
So? You produce the witness. You have to produce the witness. You just can't say that you will not produce the witness. आप बोल दीजिए विटनेस प्रोड्यूस करने की स्थिति में नहीं है, इनको अभी भेज दे देते, फिर क्या? Yes, the girl says that Mama has brought her from Pune, and you say that he is not in a position to depose. She has made a statement.
वो मामा का स्टेटमेंट हो गया, रिकॉर्ड उनका है.
तो और कोई दूसरा मामा है?
वो PW5 है, वो मामा जो वहाँ से आए हैं वो PW5 30/4/25 से कस्टडी में है, मतलब
कहाँ है PW5 का स्टेटमेंट?
PW5 मतलब चूंकि वो मंगाया गया था कोर्ट से रिकॉर्ड में, अगर
नहीं आएंगे तो फिर से आइएगा। Heard the learned counsel for the parties.
एक साल से ऊपर कस्टडी हो गया, 21 का एडमिटेड लव अफेयर है, इवन FIR में भी मतलब victim had turned hostile, मतलब even the informant had not stated, मतलब
Victim minor है recovered from Pune.
मतलब 17 years है, मतलब और वो खुद बोल रही है अपने चीफ में भी कि मैं खुद से अपनी दोस्त के पास गई थी, उनकी मदर बोल रही है कि आई हैव नॉट साइंड एनी पेपर। मतलब एक बार जो है उनका क्रॉस एग्जामिनेशन पैराग्राफ 2 देख लिया जाए, मतलब बाकी सब ईयर से बोल रही, बाकी विटनेस बोल रहे हैं कि भाग गई है उसके खिलाफ जो बिट्टू कुमार।
Heard the learned counsel submitting on behalf of the parties. The learned counsel for the petition submits that the petitioner is in custody since 34/2025, and the bail application of the petitioner was rejected on merits in BA number 5857 of 2025 by order dated 24/9/2025. He submits that the petitioner the victim has turned hostile.
And she has refused for a medical.
And she refused for a medical examination. The learned counsel for the state has opposed a prayer for bail and has submitted that as per the report received from the concerned court, only one witness is remaining to be examined. He has further submitted that he has filed a counter affidavit before this court and has submitted that Mukhya has given a certificate that the mental condition of the remaining witness to be examined is not proper, and the wife of the remaining witness has also stated that the remaining victim is not in a position to walk and his mental condition is not proper. The learned counsel has further submitted that it has come that the remaining witness, and due to illness, that the remaining witness is under the treatment of one doctor, and due to illness, he is unable to depose the statement before the learned trial. वहां जाके भी तो उनका एग्जामिनेशन हो सकता है इसका। After hearing the learned counsel for the parties, this court finds that the state has expressed certain difficulty in producing the witness before the court. However, the court has to do the needful so that the evidence of the remaining witness is recorded in accordance with law. The statement of the evidence of the victim has been brought on record by the petitioner, and it appears that the victim has turned, and it is submitted that the victim has turned hostile. However, in view of the fact that only one witness is remaining to be examined, this court is not inclined to enlarge the petitioner on bail.
A liberty may be given.
That liberty is there. They will do the needful.
If they will not do, then petitioner may renew the.
That liberty is there. If still they do not come, you come. At this, the counsel for the petitioner has submitted that the next date in the trial is on 9/7/26. उस दिन तो नहीं हो पाएगा. Maybe next.
Item 40 BA 4288 of 2026.
So it has been alleged that the petitioner has committed sexual assault. My lords will kindly see 16, page 16. That is the FIR.
A statement has come under section 182. Direct allegation.
There may be direct allegation. I am on the point that what irregularities and illegalities are there in the FIR. Second, what statement has surfaced in the investigation and how she has denied the medical examination. Third, that there is a delay in lodging the FIR about a month. I'm just coming to that one by one. केवल 4 point है इसमें. I will just state. Page 16 my lords FIR.
Custody बताइए.
Custody my lords 19/1/2026.
Charge sheet किसने हुआ? Charge frame हो गया? Charge frame.
Charge frame नहीं हुआ. इसमें first hearing also stage evidence ही अभी दिखा है.
क्या बोलना चाहिए?
Right. Let's kindly come to page 16.
16.
That is the FIR, the information.
Yes.
मैं so and so की निवासी मुक्त व्यक्ति so मेरे पीछे दिनों से हाथ लगाकर मुझे अपने चंगुल में लेना चाह रहा था, परंतु मैं इस चंगुल से बराबर बाहर रहा करती थी. मेरे साथ अचानक संध्या 4-5 बजे के बीच कैथिया ग्राम से ट्यूशन पढ़कर आ रहे थे. मुझे रास्ते में पकड़कर मुझे फुसलाने पर बढ़ाने लगा. मैं अकेली छात्रा उसके समझ काफी डर से भयभीत हो गई और व्यक्ति ने डर दिखाकर मुझे इशारा कर दिया. नीतीश पासी ने अपने घर पर लाकर मेरे मन में सिंदूर डाल मुझे धमकी दिया कि अगर किसी को बताने से जान पे मार देंगे और वह अपने घर में मुझे कैदी के जैसा रखा. मैं किसी तरह मौका पाकर उक्त व्यक्ति के घर से भाग निकली और मेरे माता पिता को वास्तविक स्थिति से अवगत कराई. उक्त व्यक्ति स्वयं से मेरे पिता के आवास पर जाकर के मुझे और मेरे पिता को जन समझ दी. Now my lords, it has come during the investigation that what the girl is saying that she informed the mother and father. The father was not residing there; he was in Delhi. So that is the first lie that is there. In the investigation, it has come. Father का बयान लिया गया है. उन्होंने कहा है कि on the date of occurrence, he was in Delhi. There could not have been any information shared by.
अपने माता पिता को या इसमें क्या है? फोन से नहीं कर सकते, कैसे नहीं कर सकते? मतलब
घर पे आए और माता पिता को बताया, वास्तु स्थिति से अवगत कराया. इसमें हम केवल 2-3 चीज जो बता रहे हैं वो देख लिया जाएगा. मतलब the alleged date of occurrence is 20/12/2025. Now there are 2 places of occurrence. The place number 1 would be the place where the alleged occurrence has taken place. That is the place where sexual assault was committed. Second is the house of the petitioner.
both these places, well, the victim has never raised any alarm. Nobody has seen them together in any means. Nobody has, even during the investigation, nobody has claimed that they have seen them together, ever. Leave alone the place of occurrence. उसके बाद इन्होंने FIR लॉन्च किया है, that is on 17/1/2026, about a month delay. 20 तारीख को occurrence हो रहा है 12वें महीने में, और 17/1/26 को जाकर के FIR हो रहा है. Now, my lords, during investigation, it has surfaced that she bluntly decided that she will not undergo medical examination. So, apart from the individual story that has been created by this victim, there is nothing against me. There is
Why
no
is she
eyewitness.
false?
There is, my lord.
What is the reason for any false implication?
Let's,
Let's pick you up.
my lord.
कोई तो reason होना चाहिए. If you say that you are not connected, nothing.
Lord, that is there at
Is
Annexure
that-
3.
What is it?
Lord, sir, what has been stated is that इनके बीच में एक आदर्श विवाह का हुआ था, and there was a dispute which rose between them, and that is how this case has been filed. Annexure 3 is there.
So there was some kind of talk of marriage.
My lord. And which broke because of certain demands or something like that, which has come to it. The
Some
point
talk
is,
of
my lord,
marriage was already there.
my lord,
What is the age of the victim?
13 years, my lord. And the boy is also aged 20 years. My lord. What I am trying to say, my lords, is that almost a month's delay, or FIR का जो मतलब, sorry, during the investigation, what has surfaced is that the father was living in Delhi. He comes back, and then 3 दिन के बाद वो आ गया. उसके बाद भी उनको 25 दिन लगा FIR लॉन्च करने में. थ्रेट कैसे दिए हैं वो नहीं बोले. It is not a case where on account of any arms or something, well, the threat was there.
Charge,
My lord.
the charge sheet has been submitted under which section?
Lord, sir, in this case, charge sheet has been submitted under 365(1) POCSO के साथ submit किया गया section 4, and cognizance was also taken. 4(2) के अंदर.
What do you say? State.
Yes, madam. The victim is, their age is minor, 13 years.
मेरे against कुछ नहीं है, ma'am. What I am trying to say.
Supported the 183.
For the learned counsel appearing on behalf of the parties, the learned counsel for the petitioner submits that as per the FIR, the date of incident is 20/12/2025, and the FIR has been lodged on 17/1/2026 after about a month. And there has been no medical evidence, no,
She is denied.
and the victim has denied medical examination. The learned counsel further submits that there was talk of marriage between the petitioner and the victim, aged 13 years, which later on did not materialize. The talk of marriage had taken place on 17/9/20. The learned counsel submits that the petitioner is in custody since
19/1/2026.
19/1/2026. The learned counsel for the state has opposed the prayer for bail and has submitted that the victim is aged only 13 years. And there is direct and specific allegation against the petitioner. And the victim has also supported the allegation under section 183 BNSS. And has also stated that her family members were threatened. After hearing the legal counsel for the parties and considering the specific allegation made against the petitioner, supported by a statement under section 183 BNSS, this court is now inclined to enlarge the petitioner and the defense rejected.
Item 41, BA 4289 of 2026.
This petition.
This minor, I think the file counter is today's time only we given file counter.
And then it is filed under the council of the state, post this case on next Monday. In the meantime, the contract will be filed.
Item 42, BA 4985 of 2026.
Became pregnant.
Yes, Madam. It has not come in the FIR, Madam. Subsequently, Madam, this
In medical examination.
medical examination, it has come, Madam. This is
The child has been born. The child has been born. Not yet.
As per my instructions, Madam, today, Madam, perhaps this year is terminated.
Terminated. Termination is so. You have without the ये तो बहुत पुराना है. Medical report is
March.
3/26.
मार्च का है।
तो बिना कोर्ट के परमिशन से कैसे
तो
termination?
पता नहीं मुझे, जैसे हमको इंस्ट्रक्शन मिला है जो उनका एविडेंस के लिए भी है वहाँ पर चार्ज हेड के उसके लिए
मेरिट में क्या बोलना?
हाँ मेरिट में है हुजूर कि देयर वाज दिस एलिगेशन इन दी मतलब देयर वाज लव अफेयर एंड व्हेन द marriage of the petitioner was
What is the age of the victim? Age.
Age model is the counter affidavit model, the age of the victim 30 years old model.
Victim is 30 years.
24 years. 23.
23 years.
20.
FIR पड़ी.
ये जो आधार कार्ड दिए हैं जो इनका डेट ऑफ बर्थ है
आधार से एज नहीं
नहीं ये जो दिए हैं स्टेट दिए हैं जो काउंटर एफिडेविट फाइल
आधार से एज डिटरमाइन
नहीं होता लेकिन ये जो दिए हैं उस पे बोल रहे हैं
यस प्लीज
निवेदन पूर्वक कहना है कि मैं रूपाली मंडल
नाम
सॉरी मैं पढ़ने में हो जाता हूँ तो मैं सेक्शन सच मानो जो 24 वर्ष की सेक्शन जिला निवासी 2 साल से अनुप माथुर के करीब होना 26 वर्ष मेरा बुरा सेक्शन प्रेम जाल में फंसाकर विवाह मुझसे कई बार शादी करने का वादा किया परंतु आज तक मेरे बार कहने पर भी शादी करने से इनकार कर रहा है वह मुझसे कई बार दीप जांच घर कई बार शारीरिक संबंध बनाया है मैंने 2 लाख से अपने परिवार वालों को नहीं बताया ये बात नहीं बताई सुनने में आया कि उनका बड़ा भाई दीपक महतो अपना छोटा भाई अनूप महतो का शादी किसी दूसरे लड़के के साथ तय किया है तथा उन लोगों की सगाई भी हो चुकी है जबकि 26 जनवरी को वह मुझे टाटा लेकर गया था और कोर्ट मैरिज करना चाहता था तथा और दबाव बनाया कि वह मुझसे मिलना नहीं चाहता है तथा शादी करने से इनकार कर रहा है इस प्रकार अनूप महतो मेरे साथ प्रेम करके मुझसे शादी करने का झांसा देकर मेरे साथ कई बार शारीरिक संबंध बनाया तो मेरे साथ there is no date of occurrence or there is nothing more
there is direct and specific allegation in this petition ये दीप जांच घर जो बोल रहे हैं ये नहीं का
सॉरी
ये दीप जांच घर में जो बोल रहे हैं कि ये गलत काम हुआ है ये दीप जांच घर ये पिटिशनर का है
पिटिशनर का है जो भी विक्टिम है वो उनके घर जाके
नहीं उसके जांच घर में
जांच कर
इनका अपना जांच
मेरा नहीं है
इनके बड़े भाई का है वो उसमें रहते हैं
she herself is saying that there was love affair and there was a subsequent promise to marry and then this offense was committed She was throughout major.
इसके अलावा भी बहुत लोग के साथ में है, बाद में सब आया, फोटोग्राफ्स भी है।
कहाँ पर है? इसके अलावा कौन से पेज डायरी, कौन से पैराग्राफ?
एज पर द फोटोग्राफ्स भी है।
डीएनए टेस्ट के लिए आते हैं।
हम तैयार हैं, तो डीएनए के लिए तो बुला भी गया था हमको, पहले तो आया भी है ऑर्डर में।
For the learned counsels opinion on behalf of the parties. The learned counsel for the petition submits that the petition has been falsely implicated in this case. And as per the FIR itself, there was love affair between the petitioner and the victim. And it is alleged that the petitioner made promise to marry and ultimately and establish physical relationship and ultimately did not marry the victim. The petitioner is in custody since
कस्टडी सिंस 25 मार्च 2026
25/3/2026. The learned counsel for the informant has opposed the prayer for bail and has submitted that the informant also became pregnant, which has come during the examination, during her medical examination. However, the child has not been born so far.
No, ma'am.
However, the child has not been born so far. To this, the learned counsel for the petitioner has submitted that the petitioner is ready for DNA test, and the question of DNA test will arise only after the child is born, and that also takes quite some time. After hearing the learned counsel for the parties and considering the fact that there appears to be an element of love affair between the petitioner and the victim, as mentioned in the FIR itself, the petitioner is directed to be enlarged on bail.
Item 43 BA 5148 of 2026.
ये बीए फाइलिंग नंबर कब फाइल हुआ?
ये फाइलिंग हुआ था वो इसी समय हुआ। एक्चुअली क्या हुआ था कि ऑर्डर शीट में कस्टडी ज्यादा दिखा दिया गया था। एफआईआर होता है 26 में, कस्टडी 25 में दिखाया गया। देखा जा रहा है ऑर्डर
जरा बीए फाइलिंग नंबर का डेट ऑफ फाइलिंग देखो 10165 of 26.
वो वेकेशन में फाइल
During the pendency of his bail application.
नहीं, पहले तो विड्रॉ हुआ, चार्जशीट नहीं हुआ तो विड्रॉ।
ये जरा देखिए बीए नंबर
और उसके बाद
फाइलिंग नंबर 10165 of 26. डेट ऑफ फाइलिंग बताइए।
दस 5:26 10165
10165 डेट ऑफ फाइलिंग क्या?
10/5/26
में 12/5/26
12/5 को कटा है 10 को
12/5/26।
उसके बाद फिर ये फाइलिंग
उसमें क्या हुआ कि ऑर्डर में आ गया कि ये कस्टडी दिखा दिया 25 में और एफआईआर है 26। तो वीडियो करके फिर से एफआईआर फिर आप फिर से हम ऑर्डर शीट लगा के फाइल।
उसके पहले यहाँ पर से
हाँ
विड्रॉन हुआ
जी, ये चार्जशीट नहीं हुआ था।
अभी क्या सिचुएशन है?
अभी है कि अब एक मोबाइल मिला है, कोई एंटीसीडेंट नहीं।
उस समय तो चार्जशीट नहीं हुआ था काउंटर।
उस समय चार्जशीट नहीं होता, ऑर्डर है मेरे पास।
The counsel for the state is directed to file counter affidavit in this case along with the criminal antecedent report. of the petitioner.
One of the कोई तो ये बिगाड़ने पे
Along with the criminal antecedent of the petitioner, the criminal antecedent should clearly indicate as to whether any case has been registered against the petitioner. Against the petitioner in the state of Jharkhand or any other state, depending upon the crime links which might have come during the course of investigation, linking the petitioner / the mobile phone recovered from the petitioner with the various offences.
one point.
Let a copy of this order be forwarded to Mr. Salim Matibari, post this case on 29th July, the counter to be filed by 27. Let the case diary along with the central be called from the government.
Item 44 BA 5179 of 2026.
Here, the bail petition was dismissed and withdrawn. Page 36, Annexure 2 is the earlier order of my lord.
Renew after framing of charge.
Yes, okay. Now the charge has already been framed. On
What is the allegation against it?
not the allegation against the petitioner and other particular that the accident was taken place. And the brother of the
No, I remember.
Yes,
Now this charge has been framed under section 105 and also 125.
125.
So what is the punishment prescribed under?
Yes, okay. There is 105 is corresponding to theatre 4 IPC. With 105 is the time.
Because on that day it was submitted and you do not have a license also. You were driving the car without license.
So for that fact,
Yes.
so for that fact is concerned, what is that you will appear from the case diary.
No, you tell us. I remember it. You did not have a license. बिना लाइसेंस के गाड़ी चलाई और किसी को गेट में धक्का मारी.
Apart from that,
आदमी मरा कि नहीं मरा?
हाँ मरा. But it may be a case of 105 punishment for culpable.
नहीं 105. I remember this. I remember this very vividly. इसीलिए चार्ज प्रिंट क्योंकि अगर स्टोर की बात 3 साल से ज्यादा का तो सजा ही नहीं हो सकता. तो हम सोचे कि चार्ज प्रिंट करा.
नहीं उसमें 279 304 एक ही केस होता जो
लेकिन वो नहीं है ना 105 भी है साहब.
105
कितना सजा होता है 105 में?
105 में तो सजा है
ना?
हाँ whoever commits the shall be punished with of life, which may shall not be, which shall not be less than 5 years, but which may extend to 10 years. Yes. Different उसका parameter 105 का जो theatre 4 का रहता है parameter. No, now he is in custody. Now he is in custody since 11/12/2025.
ठीक है 11/12/25 से तो क्या हो?
नहीं मेरा ये कहना
आप बताइए स्टेज क्या है बताइए.
अभी से चार्ज फिल्म हुआ 2/26 को चार्ज हुआ है, कोई गवाही नहीं हुई है.
कितना गवाह?
टोटल गवाह है जो इस पे
500 तो गवाही होगा.
नहीं ज्यादा गवाह है 30 गवाह है. हम चार्जशीट भी लगाए हुए हैं. चार्जशीट भी लगाए हुए हैं. चार्जशीट दिया इसमें 126(2) इनके
चार्जशीट होने से क्या हुआ? चार्ज has been framed.
Yes.
Under section 105 and 125B.
हाँ,
जिसमें minimum sentence है 5 साल.
281 105 में
minimum sentence है 5 साल.
281 105 में चार्जशीट हुआ. ये 281 ये corresponding to 279 earlier.
वो छोड़ दीजिए ना.
हम जिसपे वो तो बेलबुल का ऑफेंस होता है. तो मेरा ये सबमिशन है कि नॉट चार्ज है ऑलरेडी बीन फ्रेम अंडर सेक्शन 105 दैट इज corresponding to 304 IPC का है. तो दैट इज कंपेसेबल होगा होमिसाइड.
हम तो अपने BNSS देखेंगे हम तो हम
BNS देखेंगे. BNS पे ही जो है culpable homicide not amounting to murder. It is not a case of murder. At all, it is not a case of murder. So far the other
तो लाइफ होता ना.
मर्डर
लाइफ.
हम लाइफ तो है उसमें भी है बट इसी तो उसपे एक बहुत थीम डिस्टिंक्शन रखा गया है.
कुछ दिन बाद
द थीम
नंबर 51
थीम डिस्टिंक्शन रखा गया है उसका.
कोई बात. BA number 5179 of 2026. Heard the learned counsel is appearing on behalf of the parties. The learned counsel for the
उसी भी इसका 18 साल हुआ था. But
the
intention was
application
not
of
there. Intention was not there.
That's the bail appeal. माँ बाप लोग ऐसे ही गाड़ी दे देते हैं बच्चा लोग को चलाने के लिए।
मतलब it may be a case of a motor vehicle
नहीं,
fine should be imposed.
नहीं थोड़ा दिन रहने दीजिए अपने ठीक हो
The
जाएगा।
fine should be imposed. तो हो तो गया बहुत दिन तो
नहीं
लग
हुआ
गया
नहीं
6 महीना से जो ज्यादा लग गया 7 माह लगभग हो गया. Fine should be imposed under the Motor Vehicles Act.
or the learned counsel appearing on behalf of the parties. The bail application of the petitioner was earlier withdrawn in PA number 769 of 2026. As the charge was not framed with the permission to renew his prayer for bail after payment of charge. The counsel for the petitioner submits that the charge has been framed under section 105, 120 within bracket B of BNS. The allegation against the petitioner, he has submitted that the petitioner turned 18 years on the same day. The learned counsel for the state has opposed the prayer for bail and has submitted that the petitioner, having no driving license, was driving the vehicle very rashly and negligently and dashed the deceased at the gate, who died. The learned counsel submits that the offence under section 105 is serious offence and the minimum punishment prescribed is 5 years imprisonment. After hearing the learned counsel for the parties and considering the direct and specific allegation against the petitioner, this court is not inclined to enlarge the petitioner on bail at this stage.
Item
7 महीना हो गया कुछ indicate कर
At this stage, yes.
Item 45 BA 5469 of 2026.
In this case, we already case diary may be called for. Well, why I am making such submission initially, FIR was lodged under section 50 of the BNS. Subsequently, charge sheet has been submitted under section 108 of the BNS. Therefore, I am making prayer, my lord, let the case diary be called for. My lord, that will
आप लोगों से इतना बता दीजिए. In a case where there is an allegation of dowry, and even if the girl commits suicide in matrimonial home, what difference does it make?
I will show my lord 3 things. First, my lord, circumstances. She was suffering from epilepsy. My lord, this was the reason she has committed suicide. My lord has, in this case, my lord, these facts has come in the case diary. Conduct of the family members of the deceased is also very important, my lord. They have ransacked, set my house on fire, everything done, my lord, by them. Therefore, I am making this submission before your lordship, my lord. If everything comes before your lordship, whatever be the decision, my lord, we have to accept. Therefore, I am making prayer, my lord. Let the case diary come, and then, my lord.
कब से custody में?
Custody में है from the date of 24/1/26.
Epilepsy था इसीलिए suicide कर.
हाँ, उसका treat actually what happened, my lord, this fact has been suppressed, and because of this reason, my lord, she was once there were attack, we were started making treatment of her, and we have made an allegation to the family members that you have suppressed this fact while negotiating with for marriage. Because of these, I cannot deny this fact, my lord.
The petitioner has submitted that
And for the
the
informant,
deceased, she was suffering from epilepsy.
no, there is,
Just
they are claiming, but there is demand of 2 lakhs rupees and 1 bullet
the
motorcycle.
learned counsel for the petitioner has submitted that the deceased was suffering from epilepsy and it has come during investigation. The counsel for
But
the
my lord, there is no
informant
medical.
is present and he has denied this submission. Case diary. The learned counsel for the state is directed to file a counter affidavit in this case. Let the case diary be called for from the concerned court, along with the postmortem report of the victim and also the inquest report. Post this case on 15 July. The counter affidavit be filed by 13. हो जाएगा? 13 तक कर दीजिएगा। हाँ?
थोड़ा और टाइम।
ठीक है, 20 तारीख तक कर दीजिए। We are posting it on 22nd. कितना केस बच रहा है?